And the first thing we need to do is finish looking at our offer to purchase and contract. And then that'll help us get Unit 10 wrapped up. I have some announcements to make. We'll talk about a midterm. We'll talk about your application process, all that. But first, let's get through Unit 10. So we're in the online learning system. Under Unit 10, we have the standard offer to purchase and contract with the highlights. So the highlights in this, you'll remember, because it's in the syllabus. The commission says if it's in the syllabus, it's a candidate for a test question. So I went through the syllabus, I went through the offer to purchase and contract. And guys, one thing I noticed was that every single provision of the contract was highlighted, was in the syllabus. So again, I don't think you guys should sit down and read this thing word for word yet. You will need to eventually when you're working with buyers and sellers. But I think for now, if you just have an understanding, and remember we said too, the big focus of this is the first provision, which is those terms and definitions. And those go over defining things such as what is due diligence, what is earnest money, what is the due diligence period, etc. So where we left off, we're in the throes of the seller obligation provision. So we just talked about, as a brief review, we just talked about various things that the contract says that the seller is responsible for. What are their obligations? So they have to provide evidence of clear title, provide any payoff statements, prove if they're a non-foreign status or not. This affects tax purposes, those sellers that may not or may have a foreign investment in Real Estate Property Tax Act. We talked about the seller's obligation, the authorization to disclose the information. So providing whomever needs a copy with the contract. Access to the property. Once we go under contract, the seller has to provide reasonable access to the property for the buyer to do their due diligence. They can't deny the buyer doing their due diligence. So the home inspector is going to have to get on the property, the appraiser, surveyor, pest inspector, etc. So the seller has to provide reasonable access, and that does include up until the very end, conducting the final walkthrough. Seller's got to remove their personal property that's not part of this purchase. Affidavit and indemnification. This is a lawyerese thing that just says we spelled out the terms of when the seller can sue the buyer and the buyer can sue the seller. So the contract spells out those specifics. Otherwise, we're going to hold each other harmless unless spelled out. Good title, legal access. This paragraph right here about the delivery of the general warranty deed. This is probably the seller's biggest obligation in the contract. Their number one duty in the contract is to provide this free marketable title to the buyer. And then governmental compliance. This was the new paragraph that was just added on July 1st. Not sure if you'll be tested on it or not, but I figured everything else was highlighted. So when they update the syllabus, this probably will be too. So I went ahead and made that decision. It's too soon to be tested on yet. If you wait and take your test, then it might show up. So again, I just highlighted it. So this is where we are at the top of page 11, a little bit more to talk about with the seller's obligations. So another seller obligation they have is to pay for the preparation of the deed. If we can think about this, there's two different attorney's costs. The buyer hires the attorney. So the buyer pays for the closing attorneys. They pay the closing attorney fees. However, the seller will pay the attorney to prepare the deed and get it ready for closing. So the seller is responsible for preparation of the deed and all other documents necessary to perform the seller's obligations. The seller is also responsible for excise taxes and any kind of local conveyance fees that might be required by law. So we talked about excise taxes back in Unit 5. That's the 500th of the purchase price. So the contract spells out that the seller is responsible for paying for that. When we get to Unit 21, 21 is all about going to closing. And that's going to include all of the seller's debits, all of the buyer's debits, and both parties' credits as well. So we'll revisit deed prep and excise tax. The deed is to be made to. Who the attorney needs to know who to make the new deed to. Who's going to be the grantee? So is it the buyers named in this contract, an LLC named in this contract, a trust, a relative, or other? And we're told if it's not any of these above, then put the names in. So to help the attorney out as the buyer's agent, they may have questions, in which case they may reach out to you or your buyer to help make sure that they're properly completing the paperwork for, today they're the buyer, tomorrow they're the new owner, right? So it depends on how we want to look at this. But making sure all their deeds and other paperwork is properly filled out. Agreement to pay buyer expenses. Seller shall pay at settlement X amount, if any, toward any of buyer's expenses associated with the purchase of the property at the discretion of the lender. So first off, as part of the negotiations, the buyer may ask the seller to pay for some of the buyer's closing costs. If the seller is asked to pay any of the buyer's closing costs, what are their three choices? They can accept it and pay all their closing costs. They can reject it and pay none of it, or they could counter it. We can negotiate that. Seller paid buyer's closing cost is a completely negotiable item. Now, they do warn us that the lenders may put regulations on how much the buyer can borrow. So certain loan types have stipulations. For example, I think FHA, don't hold me to this, but I want to say FHA is like 4% of the purchase price, for example. Again, don't hold me to that. But the point is the lender may have some kind of regulation. So buyer's agents, we need to check with our lender before we start filling in this amount, asking the sellers. The last, guys, several years in this crazy seller's market, this is what that paragraph has been looking like. Seller doesn't have to pay any buyer's closing costs. So the last few years, we've not been seeing much of this. And again, this is something that's going to come back as with that pendulum brings back to a buyer's market. We're already starting to see it. Just remember, through the eyes of the seller, closing costs come off of the purchase price. So again, listing agents, you need to understand this, because when you get an offer in as a listing agent for a purchase price of $100,000 and the buyer's asking the seller to pay $3,000 in closing costs, how much are we actually offering the buyer? I'm sorry, how much are we actually offering the seller? We're really only offering them $97,000. Everybody with me? Through the eyes of the seller, this comes off the purchase price. So again, it's a negotiable term. You want to get that seller $100,000? We need to up the purchase price to 103 minus 3,000 closing costs. And now we're back down to. So through the eyes of the seller, listing agents, that's something we need to help our sellers understand, as that is a negotiating point. FHA, VA, buyers may not be allowed to pay some of their inspections. Again, we're getting there in our financing unit, so we'll talk about FHA and VA. But for example, the buyer getting a VA loan is required to get a pest inspection. The VA requires a pest inspection. However, the VA will not let the buyer pay for that pest inspection. So if the buyer's not going to pay for the pest inspection, who's left? Who's up? The seller. Listing agents, is that important to discuss when we get this offer in? Is that important? The seller understands that they may be on the hook for some of these costs. We have an addendum. We have an FHA VA financing addendum that spells out that the seller may be responsible. So again, it's another tool we can use to have conversations with the sellers. So buyer closing or seller pay closing costs. Let's see. Owners Association fees. We defined special assessments in the first provision, the terms and definitions. And then when we were talking specifically about buyers, we saw special assessments again. And we saw with special assessments that the buyer is responsible for things that are confirmed after settlement. So buyer's responsible for any special assessments confirmed after settlement. Now we're talking about the seller's obligations. And we're told that the seller is going to be responsible for any special assessments that have already been confirmed prior to settlement. So payment of special assessments, anything that's already been approved prior to prior to settlement is going to be responsibility of the seller, whether it's payable in a lump sum or future installments. So some HOAs or government special assessments may say the special assessment is X amount, this is what you owe me. Others may say we're going to divvy this up and allow you to pay X amount every 6 months, kind of a future installment thing. Either way, the seller is responsible for everything that's been approved prior to settlement. Late listing penalties, if the seller didn't pay last year's taxes, property taxes, they're going to have to pay those. This year's property taxes are going to be shared. It's going to be a shared expense between the buyer and the seller. Today's what, August 1st? Happy August, y'all. July's gone, isn't it? Today's August 1st. So if you buy my house today, is it fair for either one of us to pay the whole year's taxes? I owned it for 7 months, you own it for 5. Is it fair for either one of us? No. So what are we going to do at settlement? We're going to prorate this year's taxes. We're going to make it fair.
Julie, can I ask you a question?
Hang on, just in unit 21. So proration is coming. Yes, ma'am.
Glad you got on this subject because we got our tax stuff yesterday and we sold our house in April. So we paid taxes for January to April at our closing, or at our settlement, excuse me. And we still got our tax bill for the full tax amount.
You need to call the county.
Okay.
Yep.
Good.
I don't know why, but you need to call that county because obviously they didn't pick up on the deed transfer. So you need to let them know you no longer own. So yep, just call the county.
Because I already reached out to the bank and made sure they knew so that our old bank didn't take money out of our escrow account and pay the whole taxes.
Sure. Yeah, call the county.
Okay, thank you.
Sure. So last year's taxes, the seller's responsible for paying. Still on seller's obligations. The seller, it looks like they have a lot, but they really don't. Negotiated repairs or improvements. Remember, all repairs are negotiable. Seller's not required to do any repairs. Everybody good with that? Remember that one very important sentence that says this property is being sold in its current condition. So if the seller agrees to change a light bulb, we have amended that one sentence. Everybody with me? The seller or the property is being sold in its current condition. So if the seller agrees to do anything, we have amended that one sentence. And this is just addressing those agreed upon repairs. Those shall be made in good and workmanlike manner. And buyer shall have the right to verify the same prior to settlement. If you're a buyer's agent and your buyer wants specifically somebody with, I hate to say experience to do it, but somebody with a certification or a license, like a licensed electrician or something, then you need to spell that out in the repair request. If you're okay with the seller knowing they have a hammer and access to YouTube, and you're okay with them doing it, then we don't need to specify, and we're going to fall under this good and workmanlike manner. So if we specifically want a licensed plumber or certified electrician, then we need to spell that out. Part of those repair negotiations. Whether or not the seller is going to provide a home warranty. Either the seller is not going to provide a home warranty, the buyer may get a 1-year home warranty that the seller will pay for, or the seller already has a warranty and they're providing that information. Good morning. Again, home warranties are very negotiable. Right now, we're not seeing the seller paying for many. However, with that pendulum, we're going to start see that becoming a very, very common negotiating point from the seller. A question came in about the as is just being in North Carolina. Yeah, I don't know how other states, and I can't tell you specific about other states, but I do know with North Carolina specifically, we are an as is state. Other states may have different repair requirements. So the home warranty, and then the last thing under the seller obligations is addressing the seller's breach. We got a whole paragraph about breach. So we're getting there, and we will talk about paragraph 23. It spells out if the seller breaches, if the buyer breaches, etc. Questions on the seller obligation?
So if with under seller's obligation, if we end up, adding all of these, prices for the seller to pay. So is that the point where we need to change how much the selling price?
That should all be part of the negotiation. So back to
Okay.
our example, Kiki, if my buyer offers to pay your seller 100,000, but we want 3,000 in closing costs, and now we want a home warranty, and again, all that, like, in the seller's mind, deducts from their bottom line. So
Okay.
for a point in negotiation, we might, your seller might say, look, I'm fine with paying the closing costs and I'm fine with the home warranty, but we're going to up the purchase price to 104. So there's
Okay.
our counter. I'm good with all these terms, but the price of 104. Now the ball's in the buyer's court, right? So now they know higher purchase price, but I get my seller pay closing costs and I get my home warranty. You see it? So that, think of a ball bouncing back and forth until it stops. And that's what we're doing, is bouncing that ball.
Okay, that was like my biggest confusion. So this is the time to work through everything, the actual
Exactly.
contract time. Because at first I was thinking this is the time where everything needs to be set in stone and you
Nope.
can't go back and change it.
Remember, this form is twofold. It serves as an offer to purchase, and upon acceptance, it becomes
The
a
contract.
legally binding contract. So we're going to start with this. We're going to edit, we're going to negotiate. And then when it's all said and done, signed and communicated, we are legally bound. Yep. I see another Mary. Yeah.
Do you see, let me word it right. Do you see many people go back on the contract after they've accepted?
We call those round 2 of negotiations. Is that what you're asking? So can we go back later and renegotiate something we've already agreed to? Absolutely. We can amend the contract.
Well, the reason I ask is years ago when we first moved here and we had somebody accept, and then they're like, yeah, we decided not to sell. And it was,
Ouch.
they were going through a divorce and it was just easier to walk away. We didn't have time to take them to court, even though it was the house that we wanted. It was just easier to just walk away.
Right.
We weren't going to do the whole, it was like, okay, fine, bye.
Right. And
So I was just
unfortunately,
wondering.
yeah, and because we agree, the buyer agrees to that this property is being sold in its current condition.
Right.
And then they do their home inspection and they come back and say, hey, seller, will you do repairs? So that's another, and again, in round 2 of negotiations, the seller has 3 choices. They can agree to do repairs, they can reject doing repairs, or they can counter that. Same thing, because it might get to, well, okay, if you want this, and this done in repairs, then I'm not giving you a home warranty, right? So any of these blanks that we see on the contract, you guys, basically those are our negotiable points. That's what the buyer and the seller have to agree to. And to your point, Mary, absolutely. The parties can agree to amend previously agreed on. We can enter into round 2 of negotiations and amend anything. It sounds like your guys didn't want to renegotiate anything. They just needed to get out. And that's unfortunate. I'm sorry that happened.
I just wanted to know what to expect, kind of a thing.
Oh, welcome to real estate. No transaction is like the one you did before. So I don't know what you should expect either, right? I mean, because you're going to have some buyers that want more repairs than others. You're going to have some sellers willing to do more repairs than others. Some are willing to put up the home warranty, some aren't. Some are going to say, no, I'm not doing anything extra other than selling my house. You with me? So it's all between the parties. Somebody asked if this would be a novation to completely rewrite the contract. We're not substituting a new contract. I would think of this more as an amendment. So remember, an amendment is a change. And when we enter into, as I call it, round two of negotiations, we're probably not changing the whole entire contract. If we changed everything, then yeah, that would probably be a novation. But probably what we're amending is agreed upon repairs, or, you know, reducing the purchase price in lieu of repairs, right? There's many options here. And again, it's whatever the parties agree to. So we wouldn't be amending the whole thing in that example. It would just be that one piece, repairs or purchase price. Good questions. Provision 9 are charges by an owners association. This just kind of breaks down. Owners associations are going to have fees. Because you guys think about it, we're transferring owners in the owners association. So there's like admin paperwork involved, right? I don't know how big the process is, and I don't know how long it takes them to go into the system and switch it out, but it's got to be done. So HOAs will often charge fees for making that change. And this just spells out what the parties agree that their responsibilities for. Understand every single HOA is different. So the HOA may have a requirement that the seller pay it. They may have a requirement that the buyer pay it. They may have a requirement that they don't care who pays it, just as long as they get paid. So this is just what's spelling out things that typically may be responsible for the buyer and the seller. Understanding that, again, everything's negotiable, and also understanding that the HOA may have their own regulations. This talks about our prorations, which we just talked about with this year's taxes. Again, this is where we're heading in Unit 21. But what our contract does is it spells out things that would typically be prorated. So we said one shared expense as settlement is going to be this year's taxes, property taxes. If I'm buying your house today and we negotiate and agree that in addition to your house, I'm also going to buy the car that looks really good in the garage, now we have transferred personal property, and we're going to share this year's taxes on personal property as well. So if taxable personal property is involved in the sale, we will prorate those taxes. Rent, if there's a tenant in place paying rent, we will prorate that. We will share that rent, and then also our HOA dues, if any. Again, you're buying my house today. It's not fair for either one of us to pay this quarter's HOA dues. So how we make it fair is we prorate it. So this just kind of gives you a little bit of insight of where we're heading in Unit 21. So we'll talk about proration. We get to pick up our calculator and learn how to prorate. And we will see this very list again with taxes and rent and HOA dues. Condition of property and risk of loss. There's this expectation of the condition of property that when we get to settlement, it's going to be in the same or better condition as what it was that we saw when it was under contract. So if we go under contract and then there's damage to the property, the seller should fix that, because that wasn't the condition it was in when I offered to pay you $100,000, when I offered to pay you that purchase price. Everybody with me? So if the condition of the property is not the same or better, and understand this even addresses reasonable wear and tear. Well, who defines reasonable wear and tear? This could be subjective, couldn't it? So unfortunately, you guys, again, if two parties, put real estate aside for a second, if two parties can't agree on reasonable wear and tear, for example, the judge will determine it for them. I can't swoop in with my real estate license and say, oh yeah, that's reasonable or not. That's not up for me to decide. I can offer my opinion, but bottom line, if buyer and seller can't agree, the judge will decide for them. So if it's not in the same condition, reasonable wear and tear expected, the buyer may terminate this contract by written notice delivered to the seller. If they terminate because the property is not in the same or better condition at closing, then the buyer will get their due diligence and their earnest money back. So Let's say, for example, we go under contract and the house burns down. It's not the same condition as it was when we went under contract, is it? Now we got an issue. Is it completely destroyed? Is it partially destroyed? Doesn't matter. It's still not the same condition it was when we went under contract. House burns down. Buyer has a choice. You guys see there where it says the buyer may terminate? That means they have a choice, don't they? They don't have to terminate. If they decide to terminate, they get their due diligence and their earnest money back. Their other option would be to not terminate. And in addition to receiving the property, the buyer, if they choose not to terminate, will also receive the proceeds from the seller's insurance claim so they can rebuild. So we have choices. You're a buyer's agent, house burns down. You're under contract. Your buyer calls you and says, what do I do? They got two choices. They terminate and get their due diligence and earnest money back, or they proceed to closing and get the seller's insurance. As a buyer's agent, this has never happened to me, but if it did, I'm telling you guys right now, when my buyer calls me and says, what should I do? I'm telling them to make 2 phone calls. Who do you think the first phone call is to? Yeah, their attorney. We already got this guy because we're under contract. So the first phone call is going to be to that attorney. The second phone call, based on what the attorney says, is probably going to be to contact the seller's insurance company and see what that's about before the buyer makes a decision. Understand, I can't make this decision for my buyer. This is something that they need to decide. All I'm doing is pointing out the contract addresses what happens if the house burns down, what happens if the property is not the same or better condition. The second piece of this is risk of loss. This is letting the seller know they're still the one at risk. It's still their home until that deed changes hands. The seller needs to maintain homeowner's insurance through the day of settlement. They've got to keep it insured. I can't tell you guys over the years how many times I've had sellers say, I say, congratulations, you're under contract. And they say, sweet, I'm going to call Geico and cancel my homeowner's insurance. Whoa, 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 slow down, right? Let's simmer down a second because you still got time to still your home, whether they're living there or not. The question is, whose name is the deed in today? Because if the house gets destroyed, that's who insurance will take over. We mentioned we have a delay in settlement back in the previous paragraph when we were defining settlement and closing, the difference between. And delays in settlement just happen. They just happen. Why? I don't care. Pick a reason. Anything's possible at this point. The only thing I know to do, I don't have a crystal ball. I can't tell you why this closing may or may not be delayed. What I can do is prepare my parties for any possibility and have them have a plan B. I want to make sure everybody has somewhere safe to stay tonight. So they're not planning on moving into the house today and it gets delayed for whatever reason. So this delay in settlement, we have 2 parties under this provision. There's the delaying party and the non-delaying party. One party is causing the delay. Let's say, for example, the delaying party is the buyer because they don't have loan approval yet. The lender just hasn't been able to give that final loan approval. If we're supposed to close today, this paragraph says that the non-delaying party, in that case would be the seller, would have to give the delaying party 7-day delay. We have a 7-day delay built into our offer to purchase and contract. So basically what we're saying, we're supposed to close today. Buyer can't get loan approval. Seller has no choice for the next 7 days, but to sit still and hope, fingers crossed, that we can get loan approval and we can get this thing closed in 7 days. If the seller terminates today, they're in breach and they suffer those consequences of breach. So the seller sits still for 7 days. The non-delaying party sits still for 7 days. On day 8, if we haven't closed, now the seller may terminate. They don't have to, But on day 8, they may terminate. If they choose to, the buyer will suffer the consequences of breach. Delays are that common, you guys, that they got them built in for us into our offer to purchase and contract. Will you guys please turn with me to page 292? 292. It talks about the delay in settlement. I'm not sure what version of the book you have, but if yours says 14 days, that's been updated to 7. If yours already says 7, you're set. Does everybody see that? Is you guys still saying 14? I see pens coming out. So y'all still says 14. Okay. Again, just an update in the contract, which is why we're always looking at the most current form and not necessarily the book. Let's see, if the delaying party is the seller's delayed and the buyer has to move into a hotel, could the seller have to pay for the buyer's hotel expenses? As a buyer's agent, we would definitely have this conversation with our attorney. Yep, definitely have this conversation, because that's a great point, isn't it? I wouldn't have these hotel expenses if you didn't delay. So could the buyer go after the seller? Sure, for those hotel expenses. How far are they going to get? That's where the attorney steps in. We have Facebook has several like closed real estate agent groups that you can, get in, and where, people share ideas and thoughts back and forth. And sometimes it's nothing, but sometimes it's really interesting. And not too terribly long ago, I saw a story in one of my closed real estate agent Facebook groups, and the buyer's agent and listing agent went to settlement. They went to the attorney's office that day. Seller never showed. Where's the seller? Oh, they're always late. Give them a few extra minutes. No seller, no seller, no seller. Listing agents on the phone, texting, email, no seller, nothing from the seller whatsoever. Parties finally get up and say, well, we're just wasting time at the closing attorney. We can't do anything without the seller. So everybody, let's just go home and see what happens. Day or two later, they figured out what happened to the seller. The morning of closing, the seller got arrested. So why didn't the seller show up to settlement? Evidently, they chose not to use their one phone call to call the listing agent and tell them what was going on. See what I say when I mean anything could happen? Could you have predicted that when you woke up that morning? So anything is possible. Anything is possible. And that's why, you guys, we have this 7-day delay built into our offer to purchase and contract. Possession of the property, including all means of access. So keys, mailbox keys, security codes, garage door openers, all access to the property shall be delivered upon closing. Buyers should not be getting keys at settlement. Buyers should be getting keys when that deed records after closing. Now, some of you may have an experience or know somebody that got the keys at closing. What does the contract say? The contract says that those shouldn't be delivered until upon closing. Guys, remember, it is still the seller's property until that deed changes hands. So if your buyer wants keys at settlement, we need some kind of agreement between the buyer and the seller. And at this point, we're sitting in front of an attorney that can draft something up. But as we said last week, we try really hard. Everybody involved tries really hard for settlement and closing to happen on the same day. So it might be you go to settlement with your buyers, you leave the attorney's office, and then later that day, you get notification from the attorney that we're on record. If you as the buyer's agent has the key, then you can deliver that to your buyers. If you left it at the attorney's, and that's when they can go back and get it. I have been handed the key as a buyer's agent, and I keep that thing securely in my pocket until I get notified that the deed changes hands. Even when the buyer says, can I please just have the key? What's the big deal? Nothing's going to happen. I keep that thing in my pocket until I get notice that that deed has changed hands. And then I'm happy to meet up with my buyer wherever and provide them with the keys to their brand new home. I'm a stickler about this. My husband and I bought a house 3 years ago. Not only did I act as the buyer, I also acted as the buyer's agent. We left settlement. You know where that key went? It went in my pocket. My husband said, "Can't we go to the house?" And I said, "Nope, not until the deed has recorded, not until it's closed." So I made him take me out to lunch, and we went to Home Depot, because that's what you do when you buy a house. You go to Home Depot a lot, apparently. And then we got notice, and then we came to our home. So possession. We may have an opportunity to do a buyer possession before closing or a seller possession after closing. We're going to talk about some of our addenda afterwards, and we'll see these in just a second. If the buyer's already living there, so let's say the tenant bought the home that they've been living in, for example, then possession's already happened. The tenant already has that access and that means. Then we have a little provision here for our addenda. So check all that may be a part of this contract and attach them. Then they give us a nice little handy dandy checklist. You may remember, for example, up here, whenever there's a need to use a form addenda, our contract is very helpful. And it tells us, hey, if this applies, you need to use this form. If that applies, you need to use this addenda. So the contract is very helpful in making sure that we get the applicable addenda and other forms that are part of this offer and soon to be contract. And now it gives us a nice little handy dandy list to make sure we have everything, to make sure that we included all the applicable addenda. We are not going to go through all of these, and these aren't all of the addenda. These are just more of the commonly used addenda. These are more commonly used addenda. So we'll see, again, the ones that you could be tested on. We'll have conversation about those. I don't know that I've ever had a transaction that didn't have some kind of addenda. So again, every transaction is different. And it's going to depend. It's a case by case, which addenda applies to this, or addendum applies to this transaction. So use this as a checklist. And we're reminded one more time, real estate brokers are not permitted to draft. If you ever forget, am I allowed to draft an addenda? Be familiar with the forms, because it's going to remind us. In this case, it's letting the consumer know. Because guys, they're going to ask, can't you just draft this? Can't you just add that? Can't you just delete this? And the answer to all three of those questions are no. Because I'm not a lawyer. I'm not an attorney. I am just a real estate agent. These next couple provisions are kind of boilerplate. You'll notice they're highlighted, but they're not as strongly highlighted. Again, the syllabus says just go over these briefly, but we're not going to spend a lot of time on these. So I downgraded, and we talked about an assignment. With an assignment, all the terms stay the same. The only thing that changes is the name of one of the parties. And whether or not a contract can be assigned has to be spelled out in the contract. So our offer to purchase and contract says it may not be assigned without written consent of all parties. So if everybody agrees to do an assignment, if everybody agrees to change the name, then this contract can be assigned. Tax deferred exchange. We're going to talk about this a little bit in our investors unit. We got an investors unit section, I guess. Tax deferred exchange is a great program for an investor. It's an IRS program. And basically what this allows the investor to do is use the proceeds of the sale of this investment property, take those proceeds and use them to purchase a new investment property. So as long as you're exchanging investment property for investment property, the IRS will allow the investor to defer paying capital gain taxes on their investment property. You can defer paying those taxes. The 1031, that's exactly it, the 1031 exchange. So if you are an investor, or if you're an agent that wants to work with investors, we need to encourage our investors to call their accountant. Now we got another phone call to make, because the accountant is familiar with the current 1031 tax deferred exchange laws, and the accountant can go over the specifics of this tax deferred exchange. Back to our contract. This says it is allowed. We can engage in a tax deferred exchange. Parties to the contract. This contract shall be binding upon and shall, in order to the benefit of the buyer and the seller, and their respective heirs. When do heirs kick in? When the individual passes away. Death is only an out when you're negotiating the offer. Once we are under contract, death is not an out. So the parties are the individuals, buyer and seller, and their heirs. Entire agreement, this is just telling us that the whole agreement counts. We're not going to piecemeal it. We're not going to say, well, page 1 is good, but page 2 isn't. This is seen as one entire agreement. Computation of days, just to mention this. When you're counting days in the contract, a day in contract, in this contract world, a day is a day is a day. So Sunday counts, national holidays count, Christmas counts. So if you're going to say 5 days, you count Wednesday, Thursday, Friday, Saturday, Sunday. So in contract world, a day is a day. The other thing this tells us is that any date or time of day is referring to standard Eastern time. There was an incident a couple of years ago where a guy out in California signed something, and it's a different time in California. I think it was probably something to do with our due diligence period. And they thought they were in because California time said one thing. And this wound up to court, and da 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 da. And now we have a sentence that says, look, it's where the property is located, not the people. It's where the property is located. We're in Eastern Standard Time. This is another paragraph I think you guys are provisioned. I think you guys should read them at the bottom of page 13. And this is paragraph 23 about remedies. This spells out what happens if the buyer breaches. This spells out what happens if the seller breaches. And this also addresses attorney fees. So, breach by the buyer. If the buyer breaches, the seller shall be entitled to the earnest money deposit. They'll keep the due diligence fee. Together, the earnest money and the due diligence serve as the seller's liquidated damages. We said liquidated damages are money damages that are agreed to upfront at contract formation. And those liquidated damages serve as the seller's sole and exclusive remedy. Listing agents, your seller needs to understand pretty much all they're going to get is the earnest money and the due diligence. And you need to have a conversation. What if the buyer never shows up to closing? What if they don't show up to settlement? What if they terminate the day before? Understand the seller's got to make arrangements to live somewhere else. And if we're sitting the day before closing and the buyer just terminates, the seller probably, they're either under contract to purchase a home or they have a lease signed. So listing agents, the sellers need to understand this is all you get. Is this going to be enough to get you out of your next contractual obligation? Unfortunately, I can't make anybody go to settlement. I can't make anybody do anything. And if your buyer calls you the day of or the day before and says, nah, I'm not buying this house, what can we do? Well, I can't like hog time and put them in my trunk and say, oh, yes, you are. So this is the conversation that the listing agents always need to have with the sellers. They need to understand these liquidated damages. Let's see. Breach by the seller. If the seller breaches, the buyer's got some choices. They can terminate this contract, seller breach. get their due diligence and their earnest money to get feedback. The seller could also go after, I'm sorry, the buyer could also go after the seller for their due diligence costs. So did you spend money on the home inspection? Did you spend money on the appraisal, the survey, the pest inspection? What else? If the buyer spent any money as in connection with their due diligence costs, then the seller breaches, the seller or the buyer could go after them for those costs. Those are our compensatory damages that we talked about back in Unit 9. The point is to make the injured party whole financially. They can't go after like pain and suffering. With compensatory damages, I tend to think of invoices and receipts. You prove you spent this money, and that's the money you can get back. So the buyer can elect to terminate, get their money back. If the seller's not willing to sit down and write a check, then we take them to court. Or the buyer can elect not to terminate, keep this contract in full force, and seek the remedy of specific performance. Specific performance is the legal remedy to make the breaching party perform. So remember, the seller's big obligation, their big obligation, is to provide clear marketable title. And if they can't do that, or they walk away, or they wake up one day and decide not to sell, they are in breach. And again, your buyer's going to call you and say, what do I do? You got choices. You either terminate and get your monies, or you stay under contract and go after the seller for specific performance. This is up to the buyer. I think we mentioned the other day, remedies for breach seem a little unfair, don't they? Undistributed. I mean, the seller gets due diligence and earnest money, and that's it. The buyer can sue. So I think we can agree that those remedies for breach are unbalanced. But guys, the reason for that, there's a reason. The reason that seller breach is much harsher than buyer breach is because the seller is the one that initiated this whole thing to begin with by putting a for sale sign in their front yard and saying, my house is for sale, bring me an offer. Had the seller never done that, we wouldn't be here. So their remedies for breach are much harsher than the buyers. And then this last little piece here talks about attorney's fees. And basically what all this says is if I got to take you to court and you lose, not only do you get to pay whatever you lose money-wise, you're going to pay your attorney's fees. And guess what? You're going to pay mine too. So whomever the breaching party is, if they're not willing to comply with what the contract says, will go to court. And in addition to whatever they're supposed to pay per the contract, they get to pay everybody's attorney's fees too. Again, I think you guys should read this. Breach happens, contracts get terminated, and this is how we address. And guys, remember, all I can do is provide the information that's in the contract. So if your buyer says, that's not fair, or I want to do this, can I do that? What are we going to have them do? Call their attorney. Yep. Let's see. So now we are on page 14. And page 14 is technically the end of the contract. And I say that because page 14 is where the parties to the contract sign. So I got a place for 2 buyers to sign. I got a place for 2 sellers to sign. If you have more than 2, we have an additional signatures addendum. So we can get as many signatures as we need. If you're a buyer, seller, and an entity, we have a place, there's going to be a representative of the entity that can sign on behalf of the LLC. The rest of this is still important, but it's not an actual piece of the contract. We signed the contract on page 14. Here's our wire fraud warning. We saw these when we looked at our listing agreements. Warning buyers that plan to send their closing costs to the attorney via wire transfer. Warning to the sellers if they want to receive the proceeds, their proceeds as a wire transfer from the attorney. Bottom line, you guys, when it comes to wire fraud, real estate agents should not, and your firm probably has a very strict policy on this. We should not be emailing wire transfer instructions. This is one place of communication that you and I do not need to get involved. If your buyer or seller receives an email from the attorney or from you, including wire transfer instructions, let's just go ahead and assume we've been hacked. Because the best thing I can do to protect my buyer and seller is look them in the eyeball and tell them, I will never email this information to you. If you ever get an email from me, you need to let me know because I've been hacked. When it comes to getting wire transfer instructions, buyers and sellers need to directly go old school, and they need to call the closing attorney on a number that they obtained. Don't call the closing attorney from a number in an email, because you might be calling the hackers. So either you provide the phone number, you tell them go to Google and look it up. But we're going to go old school, have them go old school, pick up the phone, call the attorney, and get that wire transfer information over the phone. Emails, my Gmail, y'all, my Gmail is about as secure as my closet door. And there's some things I can do, like I can put two-step authentication on it, but it's still hackable. So we got to do what we can do. Think about the hundreds of thousands of dollars that change hands every day in real estate transactions, right? I mean, this is a lot of hackable money. So we got to do what we need to do to protect our buyers and sellers. And the best thing we can do is have this conversation with them. I did a wire fraud seminar down in Raleigh back in, it was pre-COVID. So it was like 2019, I think, actually. It was interesting. They had somebody from the real estate commission. They had an attorney. They had somebody from the FBI. They had somebody from a title insurance company explaining. And y'all, the FBI stood up and looked at us and said, hackers are always 2 steps ahead of us. About the time we figure this out, they've moved on to the next best, the next greatest thing. So it comes back down to make sure you and I are protecting ourselves. If you want to go work one afternoon at Starbucks, you want to take your laptop and go work for the afternoon, I think that's great. If you're doing anything with sensitive information, I would encourage you not to get on Starbucks public Wi-Fi. Who can access the public Wi-Fi? The public. So if you want to go to Starbucks and you want to work on something sensitive this afternoon, get on your mobile hotspot on your phone. Jump on this. That's the other thing they did at that wire fraud seminar. They showed us a video. They were at Panera Bread, and there was a young lady at Panera Bread. She just looked like me and you. She wasn't wearing her I'm a hacker t-shirt. And she sat down at Panera Bread and she created a Wi-Fi called Panera Bread 2. And within seconds, people from all over Panera Bread were jumping on it. Be careful with that public Wi-Fi. Be careful. Protect yourselves, protect your clients. This is our notice information. This is the page that says how we want to communicate with the parties. How does each side want to communicate with each other? So we have the option here to put our buyer or seller contact information. A lot of firms will say, don't fill this in, leave this blank. Because if the buyer or the seller have an agent, I want you contacting me, not my buyer or seller directly. So a lot of firms may have a policy that says, if the buyer or seller have an agent, leave this blank. Because this next section down here is for our contact information. And this is the only place that you and I belong in the offer to purchase and contract. And that is just to list, how do I want to be notified? How do I want to be communicated? So buyers on the left, sellers on the right. So the buyer's the selling side. So we're going to identify who the selling firm is. And then we have to identify the selling firm's role. Is the selling firm acting as a buyer's agent, a seller's sub-agent, or a dual agent? The firm's license number, mailing address. And then we're going to list the individual selling agent whether or not they're, or if they are acting as a designated dual agent, and then our contact information. So your license number, phone number, fax if applicable, and email. Then on the notice page, we go through that same little exercise on the right-hand side for the seller with the listing firm. Again, identifying the firm's role. Is the firm acting as a seller's agent or a dual agent? Firm's license number and address. And then the individual agent, who is that individual agent, and whether or not they're acting as a designated dual agent, we need to put in our license number and contact information. Again, this just notifies all the parties. How do we want to communicate during this transaction? Remember our communication of acceptance, and we can we can have communication of acceptance in any way that the parties agree. So if, for example, I do not give you my email address, is email an acceptable way to communicate with me? No, what I tell you right there. So if you want to limit, if you need to say, this is how I want you to communicate with me, this is it. This is how we can notify the other side. And then the last page of this, we got to have acknowledgement of receipts of monies. So when our due diligence changes hands, we need to acknowledge that change of hands. When the earnest money deposit changes hands, we need to acknowledge that change of hands. So let's back up for a second. We go under contract. Yay. You call your buyers, you're the buyer's agent. You call your buyers and say, congratulations, I need to meet up with you today to get your due diligence and earnest money. Your buyer says, well, I'll run out to the bank on my lunch break, meet me here at this time. And you say, great. You meet your buyer in the parking lot. Buyer hands you 2 checks, one made out to the seller for due diligence, another one made out to the escrow agent for earnest money. You as the buyer's agent are responsible for delivering those checks. Commission rule says when somebody else's money is in my hand, I'm responsible for it. If somebody else's money is in our hands, it's because we're acting as delivery man. So when you get that money in your hand, when you meet your buyer in the parking lot and they give you that due diligence and earnest money, you need to get it out of your hand as soon as you can. You need to get it to where it needs to go. Because while you're still carrying it around, you're responsible for it. So you get those checks. You're going to take the due diligence. You're going to deliver the due diligence to the listing agent. When the listing agent gets it, they're going to acknowledge. They're going to sign acknowledging that they have received it. Can we all just go ahead and agree that in your hand and on its way are 2 totally different things? There have been cases where agents have said, I'll drop the due diligence off by your office this afternoon. Go ahead and sign the acknowledgement and I'll pick it up when I drop the check off. The problem though, you guys, what if the check never makes it there? Now you have a signature saying, yes, you have received it. So we are not going to sign acknowledging the money until it is in our hand. So the listing agent signs acknowledging receipt. Then the listing agent needs to deliver it to the seller. So we're just playing as delivery man from the buyer to the buyer's agent to listing agent, now the listing agent to the seller. So the seller will sign acknowledgement of receipt so we know that they've gotten it. And then we go through that same little exercise with the earnest money. Buyer's agent will deliver the earnest money to the escrow agent, usually the closing attorney. Once the closing attorney receives it, they will sign, acknowledge that they have received it. So this is just making sure, this last page here is just making sure that that money changes hands. And that, ladies and gentlemen, is your 17-page offer to purchase and contract. Prior to July 1st, it was 16 pages. So we grew with our last amendment, our last change, we grew. This will make you, I'll leave this with you before we go to break. I bought my little condo in 2006. How many years ago was that? What year is it now? 17 years, give or take. Does that sound right? Okay. Bought my little condo in 2006, 17 years ago. When I bought my condo in 2006, our offer to purchase and contract was 8 pages. See how much we've grown in that short amount of time? Where are we going to be 10 years from now? I don't know, but I can almost promise you it's going to be more than 17 pages. So be prepared for changes in the forms. Be prepared for updates, because it's just part of the business, it's part of the industry. We need to take a break. So let's take a break. When we come back, we'll finish up our offer to purchase and contract and unit 10. So let's take 10 minutes. Welcome back. All right, so I am going to take attendance. What questions do I have on our standard offer to purchase and contract? Comments on our offer to purchase and contract? Question comes in, when I'm the buyer, not about the offer to purchase and contract, but what the heck? When I'm the buyer, acting as a buyer's agent, do I still make commission? It's up to the firm. In my case, yeah, that was the best part about buying a house as an agent. Once those keys changed hands, I got a tag on commission check. That's a fun story. What's the best part about buying a house as an agent? So it's going to be up to the firm and how they compensate you. That's how I paid my closing costs. Thank you for letting me know you're back. Questions about our offer to purchase and contract? Again, you can find the highlighted up-to-date version in the Unit 10 material, the online learning system. Okay. So our offer to purchase and contract, these pages, what, 287 to 293. Again, just kind of explains a little bit more further some of the provisions that we talked about. As I mentioned the other day, if you don't do anything else with the offer to purchase and contract, I think you should read the first provision, the terms and definitions, because that defines exactly what is due diligence, what is earnest money, that kind of thing. Of course. All right, so we're picking back up in our books on page 293. And what we're going to do now, we're not going to actually look at the forms. We don't need to look at the forms, but we do need to talk about some of our more commonly used addenda. I'm getting this confused. Addenda is plural, addendum is singular. Y'all help me with that. Okay, so our more commonly used addenda. And again, you guys, I don't know a transaction that doesn't have some kind of addenda. So our contract covers a lot. I mean, we just looked at 17 pages of it. Our contract covers a lot, but each situation may have the need for additional information. And that's what our addenda do. They add to the contract. Once added to, they become part of the contract. We are certainly not looking at all of the addenda. We're going to look at some of the more commonly used ones. And again, we don't need to look at the forms themselves, but we do need a basic understanding about what these addenda do. So probably on your test, what you can expect to see is a scenario, a situation. And the question will want to know, what's the applicable addenda? So again, having a basic understanding of what these addenda do, maybe a test question. So the first one we're going to look at or discuss is the FHA VA financing addenda. Now we'll talk a little bit more about this when we get to our financing units. But this is the form we're going to use if your buyer is getting an FHA or a VA loan. And this form pretty much does two things. In the event that the buyer terminates because the home doesn't appraise, not appraising is the only allowable excuse, but in the event that the buyer terminates because the home didn't appraise, this form protects their earnest money deposit. So even if they terminate after due diligence, this form protects their earnest money deposit. Again, the only allowable reason to terminate is because it doesn't appraise. We'll talk about this process. What does it mean if it doesn't appraise? What does that look like? We're getting to all that in our financing unit. The second piece of this addendum addresses if it's a VA buyer. Remember we said the VA requires a pest inspection, but they very rarely allow the buyer to pay for it. So this addresses that. This alerts the seller. You may be on the hook for some of these required inspections. Listing agents have that conversation with your sellers because they need to know before they accept this offer if they're going to have to pay the pest inspection, well water, septic, any of that might be required by the VA. Questions on the FHA VA financing addendum. You don't need to know the numbers, by the way, the 2A, 4T. I just put that there for reference.
Not only the earnest money, but also your due diligence money.
Nope, just the
No.
earnest money.
Okay, I
the
just want to
earnest
make
money.
sure.
Yep. Thank you for that clarification. Yep. So again, if the buyer terminates, even after due diligence, this form protects their earnest money because the home doesn't appraise. Two other addenda that we have that we briefly mentioned, and these are long, I know. There is a buyer possession before closing, and there's a seller possession after closing. So we said possession happens at closing. Possession happens when that deed changes hands and the brand new deed is recorded. That's the last act. However, the parties may agree to a different type of possession. They may agree to allow the buyer to move in before closing, or the parties may agree to allow the seller to stay after closing. So we have forms to cover both scenarios. These forms are the simplest and basic of leases that we have. Part of that is because these forms are meant for short-term use only. I would think like 7 days, 10 days. If we have a lease situation for more than short-term, we need to get an actual lease. So this is not supplementing a lease. This is just, I'm buying your house today, but you need to stay an extra day and I'll move in on Thursday, right? This is what we mean by short-term. The big thing that this form addresses, we need to understand that in either of these scenarios, one party is acting as the landlord and the other party is acting as the tenant. The party acting as the landlord must have homeowners insurance. The party acting as the tenant, I hate to say the word must, should have renters insurance. And the big part of this form is alerting the parties to the responsibility of their stuff. The landlords need to have the home protected. The tenants need to have the stuff, the personal property protected under insurance. And it addresses, you can see other things here. How much rent are you going to pay for those 2 days? Of course, I'm going to charge you rent for 2 days. So we got to agree to what that looks like. Addresses insurance or pets allowed. Who's responsible for utilities, lawn care, maintenance, all that. So buyer possession before closing, seller possession after closing.
So isn't it gonna be hard to like get like renters insurance for like a day or 2 days?
That's up to the insurance company. But what I got to do is tell them to call. Could they get? Absolutely. What's it going to cost? They're probably paying a premium for those 2 days. Yes. But again, my job is to make sure that they make that phone call. I can't force them to have the insurance, but this is what this form is addressing. Because again, guys, we hate to think like this, but what if the house burns down? I mean, you got the house, you got your stuff. We got all sorts of things involved now, right? So this is what we're doing, is protecting each other. Unfortunately, catastrophic things happen in a blink of an eye. Another commonly used addenda we see, or addendum, I'm getting us backwards today, is our lead-based paint or lead-based paint hazard addendum. We talked about this back in Unit 20. And we have this addendum. There's a for sale version and there's a for rent version. So we're identifying to buyers and tenants if the home was built prior to what year? I see mouths move. Good. I hope what those mouths are saying, I'm learning how to read lips, but I hope what those mouths are saying are 1978. I see head bob. So yes, that's what you were saying. Good. Oh, and I'm seeing it in the chat too. Thank you. So anything built prior to 1978, remember this form does not say. This house was built in 63, so it has lead in it. What this form is saying is because this home was built in 1963, it may have lead in it. And this is the buyer and the tenant's opportunity to investigate, address, whatever. Remember, you guys, lead-based paint, lead in the home affects children. It affects those developing organs and bodies. So this is why it's applicable to tenants as well, because the tenant may come with a kid or two. So making sure they understand. That's what this form is spelling out. Another form we have is the additional provisions addendum. And as soon as I flipped this slide, I thought, oh man, they updated this one. I hadn't got a chance to update my slide yet. So I will update you guys live and in action, and I will make myself a note to take care of that class. The additional provisions addendum is probably the most commonly used addenda that we have. The additional provisions addendum provides us with additional provisions. They're popular, but they're not popular enough yet to make it to the offer to purchase and contract. So some things covered in the additional provisions addendum. You could put an expiration date on your offer. If the offeror wanted to notify the offeree that their offer is good until 5 p.m. tomorrow, August 2nd, we can use the additional provisions addendum to put that expiration date on it. If the property includes, let's say, for example, it's raw land, it's undeveloped land, the question may come in, well, can I hook up to city sewer, public sewer? If not, I need to install a septic tank. Provisional additions addendum allows the buyer basically time to have the property inspected to see if it will support a septic tank, an on-site septic tank. So if there's a septic tank installation or modification involved in the property, we can get more information by using the additional provisions addendum. If there's an existing tenant and lease in place, the additional provisions addendum covers rent. It covers the seller supposed to deliver to the buyer true copies of the lease, the tenant's financials, the records and the reports of the rental property. The seller is going to release all that information to the buyer, and that's addressed in our additional provisions addendum. There's also agreed upon repairs or improvements. So let's remember first few things. First off, this is an addendum, which means we are including this when we present our offer. We could have a case where the buyer is asking for repairs at the time they present the offer. If the seller tolerates, considers these, and they agree to do these repairs, the seller is now legally bound to do these repairs because we included the addendum. We included the form. So we ask for repairs when we present the offer. The seller has three choices. They can accept it, reject it, or counter it. Let's say, for example, some things we don't need a home inspector to tell us is broke, right? Let's say, for example, you got a house. I saw one, it was had a back patio, and there was a sliding glass door that you open up and you walk through and you go out to the back patio. Well, somewhere along the lines, it looks like the lawnmower threw a stone at the patio door, and there was a little hole in it, and it was starting to spider a little bit. Do I need a home inspector to tell me that's broke and that needs to be fixed? Do you need a home inspector to tell you that that's broke and that must be fixed? Your buyer might look at you and say something like, I'm not buying this house if that door is not fixed. That's a great candidate to use the additional provisions addendum. Let the seller know that your buyer buying, this is conditioned upon them accepting that repair. Does this make sense? This does not negate the buyer from conducting their due diligence and having their inspections and investigations done once we're under contract. So that piece doesn't change. Once they've had their inspections done, the buyer may ask for repairs. Seller doesn't have to agree to do any. So again, we're asking for stuff to be fixed up front at the time they're considering the offer. But this doesn't negate the buyer's due diligence. If the property has a manufactured or a mobile home, then we're going to include the additional provisions addendum to address the specifics of the manufacturer of the mobile home. If there's a pool or a spa on the property and it's the middle of winter. So let's say an outdoor pool has probably been winterized. This is going to address having it unwinterized so it can be inspected. Obviously, this time of year, hopefully it's up and running, right? So it should be able to be inspected as is. But if it's the middle of winter and we're dealing with outdoor pool or spa, then this is going to address who's going to unwinterize it. And I'll show you guys where you can access all these forms in just a second. If you want to look at them, you're welcome to. What was added on July 1st, excuse me, to the additional provisions addendum was a provision about off-site boat slips or off-site septic systems and how those can be inspected. So there's off-site equipment. I think boat slips is like the perfect example. You get a home on a lake, you have access to the boat slip, but it's not on your property. So how is that addressed? And that was the new that was just added on July 1st was off-site property. And I have myself a note to add this. Questions on the additional provisions addendum?
You said boat slips or septic system inspections?
Any
Okay.
off-site property that, for example, yeah, a boat slip or an off-site septic system. Because the question comes in, well, if it's not on the property, how can I'm not the owner, right? So how can I inspect it? How can I perform that inspection? And that's what this is going to address. Or this is what this does address, the new. They also ramped this up, the rental income investment property. It was just like a couple second blurb, but now it's more specific, more detailed about what the seller should release. Should this be filled out before 2T? It's going to be filled out with the offer. So if we use any applicable addenda, when I present the offer, it's going to include, because it adds to, remember the addendum, it adds to and becomes part of the offer to purchase and contract. So we're going to include it absolutely with our offer. Another addendum, real estate's really fun with forms, you guys. Another addendum we have is the Owners Association Disclosure Addendum. This is going to be those times that an owners association, the property is in an owners association. We need to disclose the owners association information. Usually we can find that on the RPOs, the Residential Property Owners Association Disclosure Statement. That's that seller disclosure we looked at in Unit 7, Note 8, whatever. So if the RPOs is required, we don't need the Owners Association disclosure. However, if the RPOs is not required and the property's in an HOA, we still need to disclose the HOA information, and that's what this does. The number one reason why the RPOs would be exempt is new construction or never before lived in dwelling. So if nobody's ever occupied it, it's considered new construction and it's exempt under the RPOs. Questions on this one? Another addendum we have is our vacation rental addendum. I don't see this much here in Winston-Salem. I mean, Winston's lovely, but let's face it, people are not vacationing here. Where do we go to vacation? We either go east or we go west, don't we? We either go down to the beach or we go up to the mountains. Any body of water, Lake Norman, for example, you may come across vacation rental property. And when you're dealing with vacation rental property, you may get to deal with a vacation rental addendum. Various things about vacation property. We're going to touch a little bit more on this in a future unit, but we don't have too much to say about this. If you are in an area that is high vacation area, if you live at the beach or you live at the mountains or you're going to move there eventually, then you may be dealing with more vacation rental property. You need more training, because what I'm providing you in this class is not enough. So your firm will have to offer more training on handling vacation rental properties. Another addenda we have that I'm just going to mention briefly, because we're going to talk about this one in our financing unit, is something called a short sale addendum. So first off, let's briefly define what a short sale is. And a very brief definition of a short sale is when the seller's underwater. And what I mean by that, they owe more than what the property is worth. So in other words, they can't sell the property and get all the money to pay off their outstanding debt and liens. They owe more than the property is worth. And if the seller is a consideration, a candidate for a short sale, then the property will be a short sale property, and we will include the short sale addendum. We're going to actually look at this one. We're going to talk more about this when we get to Unit 14, because it's a really good form and it does a good job of explaining a short sale and specifics. Another thing this form does, it's unique. It creates a contingency. Remember what we said, a contingency, something has to happen before I'm legally bound to do something else. And the contingency that this form creates is actually for the seller. The seller has to get approval of all lien holders to do a short sale. If they can't, they're not contractually obligated to sell. So this form is contingent on the lien holder's approval. And again, we will talk all about the process. We will look at the form. We will see this again. Just your brief introduction to it. Brief questions on the short sale addendum. No, we're going to revisit it. And then the last one we have that we're going to talk about, again, there are others, but the last one we're going to talk about is our backup contract addendum. This is what we're going to present with an offer on a property that is already under contract. So who can remind me, first off, which offers do I present to my sellers? Which ones? All of them. And that means even if we're under contract. All offers. So the property's under contract. The buyer that is under contract is referred to as the primary buyer. The other buyers hoping to come in as a backup buyer. So this offer is presented with a backup contract addendum added to it. The buyer and the backup buyer and the seller negotiate the terms like they always would. They're going to negotiate the purchase price and the due diligence and the earnest money, you know, seller pay closing costs, home warranty. We're going to negotiate the terms as we always would. But we're going to add this backup contract addendum that puts the buyer in the backup position. And basically what it says is if the primary terminates for any reason, the backup's up. The backup gets moved to the primary position. This form only allows me to have one backup buyer. We can't line them up, you guys. I can't have a backup to the backup and a backup to the backup to the backup, right? We can't line them up down the street. So we can only have one backup buyer, one backup contract. If the primary buys, the backup isn't out any money. They don't owe due diligence until and if they become the primary. Some sellers like this, especially in these crazy markets. I mean, you guys have heard me talk about some sellers were getting 40 some offers on their one property. And the question is, gosh, if these guys terminate, are you kidding me? I have to open my door again, allow all these showings and offers, and we've got to go through this again. Well, maybe one of those 40 some that got rejected may be interested in a backup, and your seller wouldn't have to go through showings if the primary terminates. Again, no due diligence is due until and if they become the primary. Now, they will deposit earnest money, but the backup contract addendum says if you don't close, if you don't move to the primary position, you'll get your earnest money back. It's just safeguarding. It's going to hang out in an escrow agent's account. Remember, all that earnest money deposit does is show the seller's good faith. Show the buyer's good faith. I'm sorry, show the buyer's good faith. Yes, ma'am, Joy.
How does that work as far as like, when you're filling in the offer to purchase and contract and you have the backup contract addendum? In order to make it a contract, there has to be the signature of all parties and then the communication.
Mhm.
So that would still have, like, you're allowed to have that contract in place while another contract is in place just because of the addendum.
Exactly, because it's a backup offer, and upon acceptance becomes the backup contract. So there's the key there. There's the piece. It's got to be accepted. The parties have to agree to all of the terms.
And then how would that work as far as when you're filling in the blanks timing wise for settlement dates, additional earnest money deposit, stuff like that? How does that work?
So the backup contract addendum addresses the dates, and it says two things. First off, it says don't put dates in the offer to purchase and contract, because I don't know if and when this primary buyer is going to terminate.
Right.
Instead, the dates in the backup contract addendum say something like, for example, due diligence will begin upon being notified and will go X amount of days. So instead of putting a date in, we're going to put something like 30 days.
Got it.
Or 45 days. And that's again what we have to agree to, how many days.
Okay.
So if you are notified that you're moved up to a primary buyer, now our clock starts.
Got it.
To your point, I can't put a date in, a specific date, because I don't know if and when the primary is going to terminate. So instead, what we're going to negotiate is a number of days.
Okay. So in the offer to purchase and contract, you would put NA and then you would fill out the time frame, 30 days, 2 weeks,
Yeah.
whatever, in the addendum.
And actually, the addendum tells us to put in the offer to purchase and contract for the due diligence date and the settlement date. It actually tells us to put see attached backup contract addendum. So
Of
it's
course.
they're referring to each other. Isn't that helpful?
Yeah.
So they tell us what to put in there. Yep. And then they're
Perfect.
referring to each other.
Thank you.
Of course. Let's see. Did you say you can only have one backup? Yes, I can only have one backup contract. We can't line them up down the street. Is this addendum used a lot? I tell you, it gained popularity in the last couple of years, because remember those 40 some offers you got? How many of those 40, let's say 45 offers, how many can we accept? Yeah, just one, right? Which means I've rejected 44. I've rejected 44 offers. And one of those rejected offers may want to be put in a position to be the backup just in case. So I'm going to say in the last couple of years, this form has gained in popularity. Have I used this one? No, I have not. I was close. I was the listing agent and I had multiple offers and we could only accept one. And one of the ones that wasn't accepted presented a backup contract addendum after they were rejected. So we rejected their first offer and then they presented us a new offer with the backup contract addendum. Buyer and seller couldn't come to agreement on terms. So this offer never became a contract. It was rejected. Both parties went about their lives. The good news is our primary buyers bought, so we didn't need backups. It's going to be up to the seller. Like I said, some sellers, if your buyer terminates, they don't want to put their home back on the market. Has anybody ever sold a house before? It's a full-time job, isn't it? You got to make your bed every day. You got to make sure you can't just leave your cereal bowl in the sink, right? You got to throw it in the dishwasher. I mean, you got to have it show ready every day, right? It's a full-time job to sell a house. Let's just go ahead and put that out there. So some sellers say, dear Lord, I don't want to go through that again. Let me accept this backup. Other sellers may say, if this primary terminates, I want them to compete again because maybe they'll up the ante. So it's going to be up to the seller whether or not, because the seller has three choices if they're presented with an offer with a backup contract addendum. And their three choices are to I could actually hear you guys. Accept it, reject it, or counter it. Do you accept the first to sign the contract? I guess I need the rest of that. Or if you want to unmute George, whichever. I feel like I'm missing something. I'm sorry.
I was just like, do you accept the person that comes in with the first, that signs the first contract, or do you look to get the person that has that offers the most?
I got you. So in a multiple offer, I'm encouraging my seller to consider the best offer. And we now know there's a lot more involved than just the purchase price, right? You may have a smaller purchase price, but if you have somebody willing to offer, I don't know, 35,000 in due diligence, doesn't that kind of up their offer a little bit? So when we're talking to our sellers about any offer, may it be 1 or may it be 40, we need to have the seller understand all the terms and then have them decide which one they want to accept. And we're actually going to talk about handling multiple offers in just a bit. So we'll see a little bit more on that. I know one thing that happened in this crazy market, my firm did it a lot. I saw a lot of listing agents creating, like, if you have 30 offers in your hand, you could, I mean, we have to present the seller. We have to send all 30 of those offers to the seller. But instead of the seller looking at, see, it's 17 pages times 30 offers. So instead of telling the seller to look at 510 pieces of paper and saying, get back to me when you make a decision, did the seller just get intimidated? Yeah. So what I saw a lot of agents doing in this crazy multiple offer world we're coming out of is actually just creating a simple Excel spreadsheet and saying, here are the terms of offer 1, the terms of offer 2, the terms of offer 3. So in that way we can see a nice side-by-side laid out. Better to have a conversation with the seller, but whatever you are comfortable, however it works for you to present this information to the seller. As I mentioned, these forms that we just went over aren't the only forms that we have. We do have an official repair request. So if the seller does agree to do any repairs, I got a form for that. We got forms to aid in our negotiations. So for example, we have a form that's called Response to Buyer's Offer. Response to Buyer's Offer is the seller's opportunity to basically send a letter to the buyer saying, this is how I'm responding to your offer. Not required, but it is clean. It's very clear. Email will work just as well. And then we have a various of termination forms. Is the seller terminating? Is the buyer terminating? Is one party in breach? Do the parties agree to release the earnest money? There's probably, I don't know, 8 or 10 different termination forms, depending on the situation. So as I've mentioned, and I'm so not kidding when I say this, real estate is the industry of forms. We don't know, I don't know, we have hundreds of forms. Some are more commonly used than others. Every situation is different, you guys, though. Every single transaction is different. You get more into forms, you spend more time with forms in post-licensing. So a lot of these other addenda forms you're looking at, you'll meet and post. Again, in pre, we're just introducing you to it. So of all the forms that we have in pre-licensing, what I want you guys to focus on is our standard offer to purchase and contract, our exclusive right to sell listing agreement that's in Unit 8, and our buyer's agency agreement that's in Unit 8. The rest of the forms you'll meet in due time. Don't worry. Questions on forms? Few more things to talk about. Unit 10, some sales procedures and practices. So on page 296, we address submitting offers to sellers. So there's a commission rule that says we must deliver all offers to our sellers immediately, but in no event later than 3 days. You get an offer in your hand, deliver it to your seller. You get an offer in your hand, deliver it to your seller. You get 5 offers in your hand today, you deliver them to your seller. Commission rule says we present which offers? All of them. Is there an exception to the word all? Not that I know of. So we present all offers to our sellers immediately, but in no event later than 3 days from your receipt. Evidently, this is a reoccurring problem down at the Real Estate Commission that I don't understand. I can't make money if it doesn't close. It's not going to close until we're under contract. We're not going under contract until I present the offer to my seller. Why the heck are we sit on these things? I don't know either. Don't form those habits. So present them immediately. Now, you may have, what if your seller says something like, I work Monday through Friday, 9 to 5, and I'm not allowed to take any personal phone calls, texts, or emails during the working hours. I could lose my job if I take a personal phone call. You get an offer at 2. You going to call your seller and have them risk losing their job? No. When are you going to call them? 5:01, right? As soon as they get off work. Hey, call me, we have an offer. So your seller may have stipulations on when you can communicate with them and not. They're the boss, remember. You may have a situation. What if you want to go on vacation? You have a listing and you want to go on vacation. What if your vacation happens to be on, I don't know, a cruise where you're not going to buy the 5-day or the Wi-Fi package? You may not be available to receive the offers, to present the offers. If you're going to do that, you need a buddy. You need a buddy system in your office. You scratch my back, I'll scratch yours. You help me while I'm on this cruise for 5 days without the Wi-Fi package. I'll help you when you go out of town, go to your bed. You guys with me? Real estate doesn't stop because we want to take a 5-day cruise without the Wi-Fi package. Offers are going to come in and you just need to know how to address that. What if your seller is on the cruise, 5-day cruise without Wi-Fi package? Can your seller leave you instructions before they get on the boat that says accept offers that look like this? Anything over that? Can they leave us those instructions? No, I cannot accept or reject an offer on my seller's behalf, even with their instruction. Guys, remember, as a sales agent, I'm a special agent. And as a special agent, what power and ability do I have to bind my seller? Zero. So even if they give you, this is one of these, we follow their lawful instructions. So even if they say anything over this, just go ahead and accept this and tell us the good news when we get off the boat. Mr. and Mrs. Seller, I'm sorry, commission rule says I can't do that. So what do? Well, maybe they leave that decision making with somebody that's here, right? Leave it with a family member or something, somebody that you communicate with. If they don't trust their family to make this decision, we may have to take the home off the market for a few days. You guys with me? Because commission rule doesn't say deliver immediately, but no event later than 3 days, unless extenuating circumstances and your seller's out of the country for a couple weeks. Commission rule says we've got to deliver immediately, but no event later than 3 days. Just a conversation we need to have with our sellers. The other thing addressed in this last little section is multiple offers. Understand multiple offers have always been a thing, but they have gained in popularity rapidly over the last couple of years. And we're seeing that pendulum swing back. I had a teammate share with me over the weekend. He submitted an offer for his buyer. And he said, they accepted our offer. And I said, you were in a multiple offer situation? He said, yeah. And I said, how many? He said, they were like one of 12. So 12 is better than 40 some, right? Not as competitive, but we are still in a multiple offer. Some of those homes priced in that sweet spot, we're still seeing multiple offers. So they'll always be around. This is what we need to understand about multiple offers. First off, the fact that we have another offer is not a material fact, which means I don't have to disclose that. Whether or not we disclose the presence of multiple offers is up to our seller. It's the seller's decision to make. Other agents will call you and they will ask you, do you have another offer? How you respond to that is at the discretion of your seller. Some sellers, let me back up. This is what I know about buyers when they find out there's multiple offers. Buyers are going to react to this one of two ways. They want to make an offer. They find out there's multiple offers. It's competitive now. Some people gravitate towards competition. Others run away from it. Same thing with buyers in a multiple offer. Some buyers, when they find out there's other offers, they're going to up their game. Other buyers are going to say, yeah, no, I don't want to be involved in that. So seller may risk losing some buyers if they find out. And that's the conversation we have with the sellers. If your seller says, no, don't disclose, when the other agent calls you and says, do you have other offers? Remember, I never have a golden ticket to lie. So if I do, and I can't disclose, I cannot say no. We never can lie. What I can say is my seller doesn't wish to disclose whether or not we have multiple offers or not. Did I just lie? No. Did I breach my seller's promises? Did I break my seller's trust in me? No. I told them what my seller's wishes were. So understand that first off. The fact that we have multiple offers is not a material fact. It's up to the seller if we disclose or not. When you and I have multiple offers in our hand, we need to deliver them at the same time to the seller. And we can't favor one offer over the other. You can't look at the seller and say, this is the highest price, just accept this one. Remember, you guys, there's a lot of other terms that could affect. Just because it's the highest price, what if they're asking for a bunch of seller pay closing costs and a home warranty? That highest price may not look as good now, right? Because remember, that comes off of the seller's purchase price. We're not going to favor offers. What if? Let's run through the what ifs. What if one of the buyers making an offer is represented by another agent in your firm? And your firm could be on both sides of the transaction. They could collect the whole commission for seller and buyer. That's best for your firm, yes? Can I favor that offer over another? Can I push my seller towards that one because that's what's in the best interest of the firm? No. What if you are the agent acting as a dual agent and you are presenting an offer on behalf of your buyer to your seller? Can you favor your buyer's offer over any other offer? No. Remember, I mentioned that Excel spreadsheet that agents were doing? I liked it because it took these kind of factors out of it and it forced the seller just to look at the terms of the offer. What's the purchase price, due diligence, dates, etc. Again, however you want to present these, just remember we can't favor one offer over the other. And then the other thing about multiple offers, we can't shop offers. In other words, we can't pit buyers together. So when the other agent, another agent calls you, and they will, when they call you and say, what's your highest priced offer you have in your hand right now? There's no rule that says they can ask. The rule says how I answer. Shopping of offers, I can't put the two. Well, the highest price I have in my hand right now is X amount. Can your guys beat that? Would that not be pitting them together? And that's what we mean by shopping offers. We can't pit them together. And as a matter of fact, we actually have a commission rule that says I cannot disclose the terms of an offer without the offeror's permission. So when that other agent calls you and says, what's the highest price offer you have in your hand right now? Can you even answer that question? Not unless you have the offeror's permission. Is any offeror in their right mind going to give you permission to disclose the terms of their offer to another offeror? Probably not. Probably not. So again, you guys hear me. This got a lot of agents in trouble in this crazy multiple offer world we live in. Agents will call you and they will ask you, what's the best offer? They're working on the best interest of their buyer. But as the listing agent, you always need to remember who your best interest is. We got to protect our sellers. So when they call you, your answer is, you know, I can't disclose that. You know, I can't tell you that. Did you not pay attention in pre-licensing? No, don't say all that too. You want to. Yes, ma'am, Joy.
With that, it's only the written permission of the offerer. So if you get written permission of the offerer, you don't have to have written permission of your selling client.
Right, just the person making the offer, the offeror. Yep, just the person making the offer. Yep.
Unless your seller client has disclosed in writing that they don't want to disclose that to
It would
anybody.
be the buyer. It would be the buyer making the offer in this case. The buyer would be the offeror making the offer to the seller. So I have 40 buyers. I have 40 offerors, all making the offers to my seller, the offeree.
Gotcha. Okay.
Anything else about this? This just keeps it fair, doesn't it? I agree. I agree. If somebody understands the offer world, they're not going to give you permission, which is why this is such an important commission rule. If you're disclosing that, and by the way, that permission, I would even take it a step further and say in writing. If your buyer says, yeah, sure, I give you permission to disclose that. Let's look at this commission rule a different way. Okay, you are the buyer's agent. You are the buyer's agent. You have two buyers interested in the same property. Remember, agency exclusivity is a one-way street. So you have two buyers, and lo and behold, they're interested in the same property. Can I share, even though they're both my buyers, they are both my buyers. Can I still share the terms of one buyer to the other? Not without their written permission. In that case, by the way, we got to treat everybody the same. So when I pull comps, both buyers get the same sets of comps. Both buyers get the same set of information. Both buyer gets the same facts. So they can make a decision. I provide the facts so they can make an informed decision. And I think we mentioned last week about buyer's risk tolerance. So if you have two buyers interested in the same property, that's where we need to get to the bottom of their risk tolerance, because you know what both buyers are offering. You know which offer is best. But Commission Rule 58.0115 says I can't disclose that with each other. I can't pit them together. I wouldn't ask either until it came up, if it comes up. Could it come up? And that's the thing about this class. Remember, you guys, we're learning the parameters of what we do. Maybe it'll come up, maybe it won't. I don't know. But if it does, we now know Commission Rule 58A.0115 says I can't without their permission. It's break time. So let's take 10. We come back. We are wrapping up unit 10. We are clipping right along here. Me. Welcome back. All right, so I am taking attendance. And let's see, we talked about multiple offers. What questions do I have on multiple offers, handling multiple offers?
Hey, Julie.
Yeah.
So if a potential buyer, I guess the first question I have, in order for them to offer, do they need to be pre-approved?
Yes.
Okay, so that.
If I could answer that a different way. Sellers aren't going to consider an offer until they know that the buyer can buy the house.
All right, so as a listing agent, if I know someone may be offering, but they haven't been pre-approved, is that the best interest of my seller to present the offer to them?
We have to present all offers, right? So even if it doesn't have a pre-approval, it was now. What can I do in the best interest of my seller as a listing agent? I'm going to say, I'm going to advise you not to accept this offer, even consider this offer until we know that the buyer can afford it. We know that the buyer can pay for it.
Okay,
So I got to present it. I mean, if you guys get an email or a text message, my guys would like to make these following terms. Is that an offer? It's not official on the offer to purchase and contract, but it's still an offer. Again, I got to present it. When my sellers look at me and say, this isn't even an official contract, it's just in a text message, what should we do? My advice is probably going to be not to respond until we have the official. I have heard before, y'all ready to have your minds blown? I hope this is mind blowing. As a listing agent, I have gotten calls from buyer's agents before that says, my buyer's going to make an offer and it's not great, so I'm just going to send it in a text message. You guys let me know if you even consider it. Is that how you best represent your buyer? Is that how you old car? Nah. When you're presenting an offer on behalf of your buyer, you present it like it's the best daggum offer you've ever seen in your entire life, because that is how you old car. And when you call the other agent and say, yeah, this isn't great, how are you helping your buyers? If you send a text message, how are you helping your buyers? So just remember, always remember who you represent in the transaction. You got to think about what hat you're wearing in a way. Am I wearing a seller's agent hat, a buyer's agent hat, or am I wearing a dual hat?
I was reading on that some buyers agents want to be present when the offer is represented. Have you, I just want to know, have you ever had that where you want to be present when your offer is presented?
I haven't, but I have a lady that I work with, and she personally presents almost all of her buyers' offers. So she makes arrangements to meet like the seller and the listing agent somewhere. So not only is she emailing it saying, here it is, get back to me, but she's actually saying, and that's her way of doing business. That's a better way to old car, isn't it? Than saying, this isn't a great offer. Y'all let me know when you reject it. So that's a service that she offers to her buyers. Now, the second piece of that is the seller and the listing agent have to be willing to meet her. Sometimes they can't or won't, but she almost always makes that available, because it's, a lot of people will tell you, I'm much better face-to-face than I am on the phone. I am much better face-to-face than I am in an email or text message. Have you guys ever had emails get misconstrued because you don't hear the tone? You don't have so I think for the most part, we are much better face-to-face, and that's how she's handling it. Sometimes her offers get rejected, but that's how she chooses to represent her. So could you present them in person? Absolutely. Just call the listing agent or seller if it's a FSBO. Anything else? $297. We talk about contract modifications. Any change we make has to be acknowledged by all parties. So if we're going to make a change, remember earlier we were talking about this round 2 of negotiations. So let's say we're in round 2. We got a couple different options. We can actually take the contract, make the change on the contract, and have all parties initial and date that change, acknowledging the change. You guys remember a few minutes ago when we looked at our contract, there's a whole lot of words on a piece of paper, isn't there? I didn't have much room in the margins. I don't have a lot of room to write on the contract. So another option when we're making changes, we're in those round 2 of negotiations, is we have an agreement to amend the contract. An amendment is a change. So we have a form for that. Again, your firm may have a policy on how you handle these changes. Either way, what we're telling you, basic contract law says any changes need to be acknowledged in writing by all parties. Maybe that's on the contract itself or using one of the other forms they make available for us. If you are making changes on the contract itself, after a while, it's going to get hard to read. You make changes, you initial it, you email it, scan it, email it, you do it again and again and again. Who remembers old enough to deal with faxes? Those things didn't have to make many trips across the fax machine before it just became like smudgy and you couldn't make it out at all, right? So if we make enough changes and they're hard to read, at the end of the day, we should be using a new form. This would be a novation. So if we're making the changes on the contract themselves, after a while, if it gets hard to read, just do a new form, do a new contract with all the newly agreed upon terms. The other thing to understand, because we document everything, right? We're all good with that. That does include all offers. If you're the listing agent and you get 40 offers, we can only accept one. We're all good with that, right? I still got to keep the 39 rejected offers because it is a document. So you put it in your transaction file, rejected offer Smith, rejected offer Jones, well, however you want to put it in there. You don't care how you label it, but you got to keep it. We had a team meeting a couple weeks ago. My team leader was showing us something in our transaction old program. It's called .loop. We use a program called .loop. And he pulled up one of his transactions and it was buyers that he'd been working with. And he had made the comment that the buyers had made several offers before they got one accepted. And when he pulled up his transaction file, it was like rejected offer 123 Main Street, rejected offer 456 Elm Street, rejected offer, rejected offer, rejected offer, rejected. As he was scrolling, I know I counted 8 or 9 of those things. So all those offers previously that got rejected, he had to keep it. Because what do we document? Everything. And that's right. Somebody reminds me, how long do we keep everything? Everybody can show me. How long do we keep everything? At least 3 years, 3 being the minimum. You're well in compliance, Vaughn. At least 3 years. Yep. Once we have executed or signed documents, contracts, we need to figure out who gets a copy of it. First off, the parties, we have a duty. Commission rule says I have to deliver all instruments within 3 days of signing. So you go under contract, we can have acceptance and we communicate acceptance. Yay, we're under contract. You have 3 days to send that signed contract to your buyer and or seller, whoever your party is. It's as simple as sending an email with a PDF attachment. Hey guys, our signed contract is attached. I'll be in touch later to talk about what's next. Have a nice day. Did that just take you 3 days to do? So sending an email with a PDF attachment should be pretty, just remember to do it. Will you keep that sent email? I would, because that shows that's your documentation that you sent it. What they do with it when they get it, I don't care. My job is to deliver it. And that's what we need to document, was that we sent it, we delivered. You don't have to do email, obviously. That's just an example. We can share a lot through our e-contract or e-signature, e-document programs. So whether you want to email or share it through Dotloop, whatever, again, the how it gets to them is an address and commission rule. The only thing addressed is that it gets to them. So how you deliver it. We may not have to provide paper copies of stuff anymore, hard copy stuff anymore, unless your client specifically requests it. Understand, you guys, not all people are on board with electronic transactions, signatures, electronic anything. So if your buyer says, can't you just print me off a copy and deliver it to me or mail it to me? Your answer is, you betcha. Buyer and seller somehow need a copy of it. Both agents, if there are two agents involved, need a copy of it. The lender needs a copy of the contract. I've mentioned before, the lending process is without a doubt the longest piece of the contract to closing process. So buyer's agents, you get your buyer under contract. We have an accepted contract in our hand. Yay. Take time for the mini celebrations. I'm all about some small wins. So take time for the mini celebration. We're under contract. The next thing you need to do in the next breath is send that signed contract to the lender so they can get started on their thing. Lender's process is coming in our financing units. Once you send that to the lender, the next thing we need to do is send a contract to the closing attorney so they can get started on their thing. So the parties, buyer and seller, their agent, the lender, and the attorney is who needs a copy of that contract. How you deliver it, doesn't matter. Just got to get it to them. All right, I want to walk through an exercise with you guys. This will be a good opportunity for us to review that magic moment in time when it goes from being an offer to a contract. So the first thing I want you to do is y'all set your chats to private, just me. Actually, that's going to take too long. I can see everybody on one screen. Sorry. Never mind. I'm going to change my mind. Instead of chatting, I'm going to ask you guys some yes/no questions. So you can shake your head yes, or you can shake your head no. That's going to save us some time. Okay, everybody ready? I'll have you chat later. Don't worry. Okay. So we're going to walk through this magic moment in time when it goes from being an offer to a contract. Buyer offers a purchase price of $150,000 with $250 in due diligence, $250 in earnest money, $1,500 in closing costs, and a closing date in 3 months. They've asked for a home warranty, and of course, they want the dang refrigerator. At this point in time, shake your head yes or no. At this point in time, are we under contract? No. The offeror has made the offer to the offeree. That's all that's happened. The seller has received an offer. What are the seller's 3 choices? They can accept it, reject it, or counter it. So are we under contract? No. Seller has 3 choices. The seller counters with no closing costs. You are not getting my refrigerator, 6 weeks to closing. All other terms are acceptable. This is a rejection with a but. Saying, I'm good with the purchase price. I'm good with due diligence. I'm good with earnest money. What we are not good with is the closing cost, refrigerator, and the time of close. This is our counter offer. So the seller is counter to the buyer. Are we under contract? No. The buyer now has 3 choices, don't they? The buyer can accept it, reject it, or counter. Did you guys dream about that this weekend? Cool. Accept it, reject it, or counter it. So we do not have a contract. The buyer accepts the terms of the seller's counter, and they tell their agent to go for it. The buyer accepts, meaning what? They have signed, and they tell their agent to go for it. Are we under contract? The buyer tells their agent, are we under contract? Ah, now we got some mixed head movements here. I'm not under contract yet. I've got to have 2 steps. I have step 1, I have acceptance. What am I missing? Communication of acceptance. Selling agent calls the listing agent. That communication crossed the lines and says, you have yourself a deal. My buyers have accepted your offer, whatever that says. I can't see it. Now are we under contract? Congratulations. We are under contract. Did that not show up? Can't see through all my Zoom. There it is. I was looking for the bounce. Yes. We must have acceptance and communication of acceptance. We must have both before we can have an executed assigned contract. Questions on this one, this little scenario? I'm going to say most offers have a counter. Very rare that this first offer get accepted. Very rare. I mean, it's got to be pretty bad to get rejected, right? Even a bad offer. I encourage my sellers to counter it because what's it going to hurt? Maybe we're calling each other's bluff. I don't know. But we always encourage a counter. You never know. The worst they can say is what? Reject. No. Questions? All right, now private chat time. I knew I would get there. Everybody still have your private chat set up that I didn't let you use last time? All right, tell me in a private chat, all you have to tell me is A, B, C, or D. Anybody in? I'd like to hear from everybody. If you don't know, guess. Okay. So let's see what we got here. On Sunday, a listing agent receives a written offer for $145,000 on a house listed for $154,900. Not in this market. So we got a purchase listing price of $154,900 and they make an offer of $145,000. On Monday, the seller counters at $149,900 and gives the buyers 3 days to accept. Wednesday, the buyer rejects the counter, and upon being informed, the seller says, no, I will accept the buyer's original offer. Under these conditions, we have nothing, because a counter offer is a rejection. A counter offer is a rejection. So when that seller countered at $149,000, this original offer was dead on the table. You can't go back. Now, could the seller at this time present a brand new offer to the buyer with those terms? Could they do that? Yes, they can present a brand new offer with those exact same terms. They can't go back. Understand that, you guys. Once it's rejected, it is dead on the table and there is no going back. Questions on this one?
So not exactly on this, but is there a limit to how many offers one person can make at all?
Nope.
So you just offer all day long, so,
Sure.
okay, I'm just
Yep.
making sure.
Yep, there's no limit to how many times we counter, how many offers you make, as long as you got the money to back it up. Because if you make 10 offers today and all 10 of those sellers accept, you got to be financially prepared too. You with me? So as long as you got the financial means, sure. Anything else? The rest of unit 10, I call alternative land conveyances. There may be some other methods to convey property other than the traditional for sale that we typically focus on in this class. Yes, ma'am.
So with that, kind of to piggyback off of his question and your answer, you're saying that, okay, so let's say I saw 2 properties and I wanted both of them. I was ready to make an offer on both of them. I don't have the financial means to put in an offer on both properties because if both sellers sign, then I'm under contract twice.
Mhm.
Can you put in an offer on one of the properties? And then if the other property is maybe not under contract already, can you put a backup offer? Does that
Well,
make
it would
sense?
have to be under contract to put a backup offer.
Okay.
So the question is, you like 2 properties and you want to make an offer on both.
Right,
I have the answer for you coming up in this next section. So hang on to that for like 1 second and I will address that.
okay,
This next section, alternative land conveyances, if it's not the traditional for sale, we have some other options. And that's where we're heading in this last section in unit 10. Please listen to me. This last section in unit 10, we're getting ready to see a bunch of green stars. Of unit 10, this is not the most important thing that we cover. Green star meaning we have to have a basic understanding. So we're going to get through this pretty quickly. The other thing I have to say, the methods that we're getting ready to talk about, the alternative land methods that we're getting ready to discuss, aren't our only options for alternative methods. They're just some that they wanted to bring to our attention. I think the best example of an alternative land conveyance might be, for example, a rent to own or a 2-year possession to purchase, 2-year possession to purchase. So that would be examples of some others. Now we have some others that we're going to start looking at on page 298. And the first alternative land conveyance method that we have is referred to as the installment land contract. And with the installment land contract, the buyer's buying and the seller's selling. And the buyer's paying the seller. But the buyer is not paying the seller in one lump sum. The buyer is paying the seller in installments. So we have to agree to the terms. How much am I going to pay you? How often? We have to agree to the terms. This type of alternative closing method combines the for sale piece of it, and then it adds the seller as the financing instrument. So instead of paying the bank, the buyer's paying the seller. Now, when we get into units 14 and 15, we're going to talk about seller financing. The difference between seller financing and installment land contract, the only difference that I know of, is when the deed changes hands. In seller financing, the deed changes hands at closing. In an installment land contract, the deed changes hands when the last payment has been made. So the seller's going to keep the deed. The buyer's going to make payments until it's paid in full, and then the deed changes hands. Then the buyer gets the deed. So let's look first at an example, and we'll talk a little bit more about that. A buyer agrees to purchase the real property and pay the seller the sum of $105,000 in the following manner. I'll provide you $5,000 at the execution of this contract, the balance of $100,000 along with the interest rate of 12% until paid in full. Principal and interest shall be in 240 installments of not less than X amount per month beginning on this day in March. So it's pretty clear. The buyer knows how much, for how long, when it's due, again, instead of paying the bank, the buyer's paying the seller. There's pluses and minuses to everything. This could be, question came in, is this like a rent to own? No. The buyer is not a tenant. The buyer's living there. They have the rights to live there. Again, instead of paying Bank of America, they're just paying the seller. They're not paying rent. They're making installment payments on the sales price. So there's pluses and minuses to everything. So let's break this down. Advantages to the seller, they still have the property in their name. So they may be eligible for some tax benefits. Have them call their accountant. This could be a way to sell a hard to sell property. Maybe it needs a lot of work and it takes a special buyer that has the tools and the knowledge. So maybe we can work something like that out, a hard to sell property. The biggest advantage to the seller, they keep legal title. The buyer has something referred to as equitable title, which we'll meet in the financing units. Equitable title gives you permission to live there. If any of you are a homeowner and you still owe the lender money, you have equitable title. The lender allows you to live there. Again, heading to our financing units, please bear with me, more on that. The seller keeps the legal title. In the event of the buyer's default, if they stop making payments or if they miss a payment, the seller has to allow the buyer 30 days to come up with what they owe. And after 30 days, if they can't come up with what they owe, then the seller, in a sense, terminates the contract and the buyer's got to get out. So the seller has some protection. And remember, the seller still has the deed. So if this gets ugly, if we have to go to court, the owner of record is still the seller. That's the leg that they have to stand on. The big disadvantage to the seller, they'll get paid the purchase price, but they're not going to get it all up front. If your seller needs all the money now, they may not be able to consider an installment land contract. So a lot of it just depends on their situation. Advantages and disadvantages of the buyer. This could be a good advantage if the buyer has poor credit. Maybe the seller's willing to work with them. Maybe they've had a string of recent medical bills that has messed up their credit, for example. The bank, the lender may not be able to help them out, but maybe the seller. The buyer's living there, they may be paying taxes. So again, they too may have tax advantages. Tell them to call their accountant. The big disadvantages to the buyer, in the event of their default, not only the seller can call the whole note due, give you 30 days to come up with the whole note. If you don't on day 31, you're out. On day 31, if you're out, any money that the seller had previously collected, they will keep. So the seller doesn't have to reimburse or refund. And another big disadvantage to the buyer, it's not their property yet, so they can't use it as collateral. They can't use it to try to, borrow other money against the house, the property. So an installment land contract, again, we'll see this briefly, compare this to seller financing when we get to 14 and 15. Let me ask you guys a yes/no question. If you're the listing agent and you get an offer from a buyer to do an installment land contract, do we have to present that to our sellers? I see head shaking yes. Why? Because we present all offers, and an offer to do an installment land contract is an offer. The other thing I have to say about this, we do not have pre-printed forms for this. So if your buyers and sellers want to do an installment land contract, I already got you guys calling your attorney, because I don't have a form for this that we can use, which means somebody's got to draft. And who drafts? The attorney. Questions on the installment land contract? Another alternative method is the option to purchase. The option to purchase is our one example of a unilateral contract. In a unilateral contract, how many sides have to perform? Just one side. Unilateral is one. This is our only example of a unilateral contract. Everything else we do is bilateral. So our unilateral contract example is the option to purchase. With an option to purchase, the buyer has not promised to buy. The buyer has asked for the option to buy. The buyer has made no promises to the seller. The way these things typically work, buyer and seller negotiate and agree to terms. And basically those terms say, if I agree to buy, these are the terms that I will agree to buy on. So the buyers made no promises. The buyers only requested the option to decide if they want to buy. Joy, this is going to answer your question. What do you do if you want to buy two properties, but you can't lock yourself down? Maybe we consider having an option for both. This could be one possibility because the buyer's not locked down. The option has a period of time. The buyer has to decide by the end of that period of time whether or not they're going to buy under these terms or not. If they choose to buy, we have a bilateral contract. If they choose not to buy, that's their option. That's their right. So we said this is a unilateral contract, which means only one side has to perform. The buyer's not the one performing. The only promise made during an option period, the seller promises not to sell to anybody else. The buyer's basically locking the seller down. And that's the promise made. I promise you during this option period, whatever we agree on, is it a day, a week, a month, a year? Whatever we agree on during this option period, I will not sell my home to anybody else. Another thing that makes this very unique is most contracts require only one form of consideration. The option to purchase requires two forms of consideration. If the buyer agrees to buy, we have the agreed upon purchase price. The other form of consideration is the option fee paid by the buyer to the seller for the buyer to have that option time. I get the question a lot. Why would a seller agree not to sell during this option time? And my answer to you is the option fee. Money talks, yes? And usually that option fee is pretty healthy. Offer me $10,000 for me not to sell my house for 3 months. Where do I sign? The option fee is usually pretty healthy, and it is a required form of consideration. If the buyer chooses to buy at the end of the option period, that option fee will be credited back to them. If they don't choose to buy, the seller keeps it because they allowed the buyer that option.
So it's like a due diligence, just not.
No, it's not, because due diligence is involved in a bilateral contract. There's two promises made. The option fee, the option period is a unilateral contract. So please don't combine those two. They are two separate things. They do two different things. Are they similar on the surface? Sure. But I
Okay.
don't want you to combine those two. They do two different things.
So with the option fee, it's not refundable at all under any circumstances.
That's a pretty strong statement. I mean, you
I
know,
know.
but for the most part, the option fee is not refundable because
Okay.
that's what the buyer's paying the seller for. Like I said, you're locking down, you're
Mhm.
locking them down.
Yeah. Okay.
Listing agents, you get an offer from a buyer to do an option to purchase. Do you have to present that to your sellers? Yep, because it's an offer. We present all offers. I once again don't have a form for this. So if we're going to do this, we got to make a phone call. Yes, we got to get our attorney involved. The other thing I have to say about this and the installment land contract, but I think it's more important here. These are, they're gonna have to be recorded. Remember our Connor Act? Connor says there's certain documents that have to be recorded. That's what protects the buyer from the shady seller selling out from underneath them. So just because the seller says, yeah, I promise I won't sell for a year, are we going to take them at their word? No. How are we going to protect that buyer during their option period? The attorney's going to record these things. So if the shady seller does try to sell from out underneath the buyer, it'll show up in the closing attorney's title search. In what cases would a buyer usually use the option? Well, I think the example that Joy gave earlier is great. You want to buy 2 houses, but you don't know which 2 you want to buy. Now, Joy, you may not be successful in this market because the sellers have other buyers. But again, when that pendulum swings back, I think another example, the one I typically use, let's say you work for big corporate USA and they want to buy a warehouse in, I don't care, Wilmington. And they send you down to Wilmington to find the warehouse. And during your travels and investigations in Wilmington, you find 3 warehouses that could be perfect for corporate USA. One thing we may want to consider would be offering an option for those 3 so we can have time to investigate, have corporate USA come to Wilmington and check out the warehouses. You with me? There's many excuses, but what we're doing, essentially what we're doing is we're basically locking the seller down. And I think we might see it more in commercial than residential. Can be happen in residential. Please don't let me make you think otherwise. But I think where we see it mostly in commercial, because commercial buildings require more inspections and investigations. And so maybe to allow you that time, especially when you're looking at maybe 2 different buildings, commercial buildings, and to allow you that time to investigate, decide which one's best, we may want to consider an option. So no form, call an attorney, present all offers. Questions on this one? The last alternative method we have to conveying property. I got a couple different preemptive rights. Before we talk about those, let's first talk about what a preemptive right is. So a preemptive right is a contractual right to acquire property before others. You are contractually obligated to offer to sell it to me, or I'm contractually obligated to offer you to buy it before I open it up to anybody else. And we have a couple different types of preemptive rights. The first type of preemptive right is the right of first refusal. This, I think, is something common to find in leases. Somebody asked about a rent to own a few minutes ago. I think this would be more common to find in leases. The owner's not promising to sell. What the owner is saying in a right of first refusal is if I do decide to sell at a later time, I'm contractually obligated to come to you first. So maybe I don't want to sell now. Maybe you're a tenant, and dang it, you're a good tenant. You pay your rent on time every time. Do I want to let you go? No. And then you start expressing how much you love my home and you're happy here and you could live here for the rest of your life. Do I want to let you go? No, you're a good tenant. But maybe what we do is a right of first refusal. It says, fine, tenant, because you're such a good tenant, I don't want to sell now. But when I am ready to sell, I got to call you first. The other preemptive right is the right of first opportunity to purchase. Again, if the seller decides to sell, I got to contact you first. The difference is we've already agreed to the terms. We agreed to the terms when we entered into the right of first opportunity to purchase. So if I decide to sell at a later date, this is what I'm going to sell it for. Let's say either one of these, We're gonna do a side-by-side compare in just a second. Let's say you live next door to the corner lot in your block, and there's a big corner lot next door to your house. And maybe you have no interest whatsoever in that corner lot. However, you don't want Dollar General to buy that corner lot either. You may want to consider entering into a preemptive right with the owner of that corner lot. So when Dollar General shows up, they have to come to you first, either one. You want to agree to the price now or later. So there's several different reasons why we could agree to do these preemptive rights. Do you have to present an offer to do a preemptive right? Listing agents, you get an offer to do a preemptive right. Do you have to present it to your seller? I don't have a form for this, et cetera, et cetera. The big difference between the two and the right of first refusal, we're matching, like I said, a bona fide offer. An offer's come in, I'm giving you the opportunity to match it. Right of first opportunity to purchase, we've already decided on a sales price. Big difference between the two. So that right of first opportunity to purchase says, if you decide to buy later, this is how much you're going to buy for. And those are our Green Star alternative land. Again, you guys, this isn't it. We get questions about rent to own. We get questions about two-year possession before closing, for example. So there's other scenarios, there's other possibilities. This is just an idea of things that we may encounter. What I heard in this conversation was lots of, I don't have forms for these. So we have attorneys involved pretty early in these transactions. And that's probably why we don't cover these much here, because this is the attorney's job. Our job is to say, wow, I don't know what a preemptive right is. I need to investigate and learn to best help my buyers and sellers. That's exactly right, Tim. And I think that's the problem with the right of first opportunity to purchase. I mean, that sales price, what it was today is not what it was 10 years ago, is not what it will be 20 years from now, you know? So there's a lot that can change between now and then. And I think that's why this one, the right of first refusal, is probably used more often, because that's exactly right. You're locking the seller down to this sales price for how long? Is it 5 years, 10 years, 20 years? So from the sellers, I'm more apt to agree to this, but they decide. We can have attorneys that help them explain, understand the differences. Each situation may depend. If you ever get the opportunity, that my Winston-Salem, my Triad people, if you ever get the opportunity to show property in Old Salem, jump on it, because they're like really fascinating homes. So yeah, jump on it. But one thing I've noticed with Old Salem is they have a right of first refusal. So if you're submitting an offer in Old Salem, then we need to learn more about this, because Old Salem Inc. has a right of first refusal. That's got to be run by them before any other offer can get accepted. Questions?
So the
Can
listing,
I'm sorry, go ahead.
Yeah.
so the listing agent would be obligated to disclose what that offer is only whenever they have that right.
That's right. And there'll be verbiage in there, because if you're going to want me to match a bona fide offer, don't I have the right to see and know what that offer is?
Okay.
And that's where the attorneys are going to be involved to help us with that language. Yep. That's kind of like the exception, an exception. Yep. Mary, was that you?
Yeah, I just wanted to ask another question, because it was kind of confusing. When I was reading the right of first opportunity, you said that the sales price is already decided.
Mm-hmm.
So was that decided 10 years ago, 5 years ago, today? I mean,
Exactly.
if I say
It's
that
when we entered into this preemptive right.
so
And
I
what
could
that says
decide it
is,
10
if
years
I agree,
ago.
if I ever buy your house,
If I ever buy. Okay.
tomorrow, 5 years, 10 years.
Okay.
If I ever buy your house, I'm going to buy it under this price and these terms.
Okay.
And
That's what I thought I just want to make sure that's what, okay.
from the seller standpoint, no, because that could gain in value 10 years from now. I get more money in 10 years from now. So from the seller standpoint now, with that being said, what are you offering? What are you offering me too? Because again, money talks pretty loudly, doesn't it? Yep. All right, you guys, key terms are on page 269, key point review. It's on 302, your student quiz on 304. You've heard me say it, you'll hear me say it again. Units 7, 8, 9, and 10 are heavily tested units. Do I need to say it again? Does it hurt? 7, 8, 9, and 10 are heavily tested units. We are moments away from moving on from units 7, 8, 9, and 10. We've got to. You guys have got to keep going back and refreshing and reviewing 7, 8, 9, and 10. Fair enough? I joked earlier about you guys dreaming about reject, accept, or counter. I actually had a pre-licensing student tell me once that I had her waking up in the middle of the night going 7, 8, 9, and 10. And I said, perfect. That's exactly where I need you to be. We get it? Okay. So we're going to go ahead and take our break. When we come back, we're going to Kahoot and, do a few other things to officially wrap up 10. But let's take 10. We come back. Gosh, it's noon already, isn't it? Welcome back. How we doing? You doing good? Good. So let me take attendance and y'all have your phones. Let's go ahead and grab those because we are going to Kahoot. So this is our contract Kahoot. So this is from units 9 and 10. Easiest way to join a Kahoot, scan the QR code. It'll take you straight to it. You're using the website or the app, you need a game pin. The game pin for this Kahoot is 962-8312. Putting names in. I think you guys can choose your avatars. For time's sake, I ask you just to take what they give you. We could spend all day picking our avatar, couldn't we? I don't have that kind of time. Welcome back. Again, you don't want, if you don't want a Kahoot, you don't have to. This is optional. I do just ask that you, if you don't want a Kahoot on your phone, you still just play along in your mind. I hope Kahoots serve twofold. Help us clarify some very basic information and to have fun. Try to interject some fun into it too. Is there anybody in that wants to play this time? Anybody in? All right, let's Kahoot. Units 9 and 10. Question number 1. A void contract is one that is ten seconds. A void contract is one that is, good job you guys, not legally enforceable. Remember from Unit 9, there's only 2 types of contracts. They're either valid or void. And what the judge is looking for, the difference of the two, the valid one has the essential elements of a contract. The void one does not. A contract, a valid contract can become voidable. It's not the contract that's a problem. The contract is valid. It has all the essential elements, but it can become voidable because how many of the parties has the right to take it to the judge? Voidable. How many parties? Just and only one. One party, this contract, has the right to take this to the judge and say, I shouldn't be expected to carry through with the terms of this contract. You can't force me. Examples we gave of who that one person is that could make it voidable could be the minor, could be somebody that was under the influence, somebody that was under duress, under undue influence. Not in writing is unenforceable. A valid contract that's unenforceable. And then rescindable means either party can rescind, and any legally binding contract is going to have the opt-out. What do we do if we terminate? What do we do if we rescind? We talked about rescinding a contract, for example, with timeshares. We said 5 days with timeshare, 7 days, they can rescind it. Questions on this one? Let's see who got it right the fastest. Nige, I'm going to call you, was out the gate first. Y'all tell me who you are. Followed by Sabrina and Dimples, whoever Dimples is, cute, Vaughn and Mo. Sabrina, that's so funny. I just realized you were here. Okay. Question number 2. The essential elements of any type of contract include all the following except. Ten seconds. Essential elements of any type of contract include all the following except agency disclosure is not an essential element. Remember, essential elements are those required ingredients that the judge is looking for to determine the validity of the contract. Agency disclosure is in no way, shape, or form a contract. We don't use it in contracts. So what are we looking for? Offer and acceptance is our meeting of the minds. Offer and acceptance is that mutual assent. So we have to have that. We have to have competent parties. We have to have some form of consideration. And the other thing here is we have to have legality of object. So in other words, you can't have a legally binding contract for an illegal purpose. Those essential elements, please refer back to page 257 of your book. 257 lets us know the essential elements of a contract. Questions on this one? Let's see, we got Nige still on top, Dimples, Joy Laura, Kai, and Sabrina. Mary's our highest climber, up 4 places. Question number 3. The law requiring real estate contracts to be in writing, to be enforceable, is the eight seconds. Please do a side-by-side comparison of these. Do you see how tricky these can be? They're close, but they're different. Connor says what? There are certain documents that have to be what? What does Connor say? I see mouths moving through laughter. Y'all kicking yourselves? Go easy on yourself. Go easy. This is how we learn. Sometimes we have to fall down to learn, right? Okay. Connor says there are certain documents that have to be recorded to be enforceable. Statute of fraud says there's certain documents that have to be in writing to be enforceable. They're both about making documents enforceable. Connor says to record. Statute of fraud says put it in writing. Please do a side-by-side comparison on your flashcards. Connor's about recording. Statute of frauds is about in writing. Questions on this one? Statute of limitations just says you have a certain amount of time to bring lawsuit against somebody. Once the statute of limitations runs out, you've lost your right to sue. Parole evidence rule says the final written word will prevail. So previous negotiations and advertisements mean nothing if it doesn't wind up in the final written word of the contract. See what they like to do to you on your test? This is it. Tricky, tricky, tricky. Questions? See what we got. Kai's on top now. He's on fire this round with 3 in a row. Nige still on. A is on the board. Dimples and Joy Laura are still on the board. Question number 4. If the seller makes a counteroffer, the prospective buyer is five seconds. Seller makes a counteroffer, the prospective buyer they're relieved. A counteroffer is a rejection. So if the seller makes a counteroffer, the buyer now has three choices. What are the buyer's three choices? They can accept it, reject it, or counter it. Nobody is bound to nothing until we have acceptance and communication of acceptance. Nobody is bound to nothing until we have a contract. Questions on this one? Let's see what this did. Nijay is back on top, followed by Dimples and A. Joy, Laura, and Kai still on. Mo's our highest climber, up three places this round. Question number 5, to rescind a contract. One is right to it. I like it. If you're rescinding your contract, you are canceling it. You are taking it back. If you put down any money, you'll get your money back. If you rescind it, both parties go about their lives as if this never happened. How many days to rescind a timeshare? 5. How many days to rescind a new construction condo? I'll put my pencil down for that one. 7, however you like to do it. You're rescinding it. If you're changing it, you're amending it. A change or an amendment is a change. Substituting it is a novation. Questions on this one? Nige and Dimples are still on top. Joy, Laura came up. Kai came up. Mary's on the board. D is our highest answer streak. They're on fire with 3 in a row. And I think, number 6, to assign a contract for the sale of real property is to ten seconds. If you're assigning it, you're transferring your rights and responsibility. Remember, in an assignment, all the terms stay the same. The only thing that changes is the name of one of the parties. So you are assigning your duties and responsibilities to somebody else. Whether or not a contract can be assigned has to be spelled out in the contract. Questions on this one? So Laura climb up. Kiki's on the board. Nige is still on. Kai and Dimples. Sabrina's our highest climber, up 3 places. And the last one, in the event of seller breach, the buyer can sue the seller and force them to sell. This is called specific performance. If you guys will, when you see this, see the word perform. If you're going after somebody in court for specific performance, when you win, if you win, the judge is going to make the other party perform as promised. What's the seller's performance? To sell. So if the seller breaches, say they wake up tomorrow and say, nah, I don't want to sell my house. The buyer could go after them for specific performance. And if they win, the judge could make the seller sell. Consequential damages are money damages. Those are the kind of foreseen things, maybe additional attorney's fees, for example. Buyer's home inspector damages the seller's property. Questions on this one? All right, big reveal. Let's see. Our third place podium winner is Kai with a little top hat. Our second place podium winner is Dimples. You'll have to tell me who you are. And our first place this round is Joy Laura. I got fourth and fifth winners up of Mary and Kiki. Good job. That was a good Kahoot. Questions? Do you guys hear that? The Kahoot music? Can you hear it on your end a little bit? I should have known that just by looking at you. Thank you. I try to keep it quiet because, I mean, to me, Kahoot music is like the most annoying music ever. I hesitate to call it music. So if it's distracting, remind me and I'll try to mute it, but I don't remember otherwise. Questions? Okay. So let's look at a few things here. Down in our Julie folder, we have our tentative schedule. Because it is officially August, I think it's a good point to remind you guys of some dates as we come into our last month. So as a reminder, you have a cram course on Saturday, August 26th from 11 to 3. That's with Dr. Bowser. We will send you her Zoom link the Friday before. And that way, when you go to log on Saturday morning, it'll be at the top of your inbox and you don't have to search it, hunt it down. Fair enough? So probably Lane, she usually does it, but Lane will probably send you guys Jane's Zoom link on the 25th. So you'll have it closer that date. This is completely optional. It's not required. It's not mandatory. You cannot use it to make up lost time. You won't miss time if you don't go. Cameras don't have to be on. This is not included class time hours. This is completely above and beyond. If you can't come for the whole time, come for what you can. Now, I don't think Jane records, but if you're not able to attend, I mean, best bet is to be here. But if you're not able to attend, in the online learning system, you guys see where it says cram, this folder, we have a cram course recording in here. So if you're not able to attend, which I think you should if you can, but if you can't, we have that available for you guys. Questions on the cram course? Okay. Other August dates and 30 days from now, guess what we'll be doing? Is this hard to believe? Our final exam is August 31st. We will talk about exam rules and expectations. As a matter of fact, this is the last thing that we talk about on the 29th. So we will talk about exam rules and expectations. Remember, it's online. You will log on to Zoom like you always do. That piece isn't going to change. Your exam will be administered on ClassMarker, a program called ClassMarker. If you are not familiar with ClassMarker, I refer you back to this email from Lane that you guys got that you use every day to access class. And within this email from Lane is a little tutorial on ClassMarker. So if you want to see how it works, I encourage you guys to watch this tutorial if you haven't already. Again, we will talk about the rules and expectations about our end of class exam. It's too soon. We got to get a little closer. Also remember, if you don't pass the end of class exam on the 31st, but you make at least a 50%. Is everybody with me? You don't pass on the 31st, but you make at least a 50%. You are eligible for the retake on September 5th at 9:15. Again, details to follow. I don't know yet who's going to minister it, but by the time we get here, we will. So we'll have a Zoom link for you guys. We'll take care of that. I just need you guys to mark the date now. Pencil it in. If you pass, you don't need it. But if you don't pass, we need this date and time available. 75 is passing. Thank you. 75 is passing my exam. So if you make a 74.4 down to a 50%, you are eligible for the retake. If you make under a 50%, you are not eligible for the retake. If you don't pass this class, you got to try it again. You've got to keep going in a pre-licensing class until you pass. And that's heading me to where we're, I may wait till Thursday to talk about the relent book. Questions on our upcoming dates? Yeah.
Sorry. How long after the final exam and the retake exam do we have to access the Thinkific?
So the online learning system, you guys will have, that's a great question. Thank you. You guys will have access to the online learning system for 4 months after class. If you need it for longer than 4 months, just reach out to Lane. Let Lane know. I need it for 5 months. I need it for longer, and she'll extend it for you, but she's got to know. So if you need it for longer, we want you guys to be able to use this platform to help you with your state exam as well. Other questions?
So how long after the final exam do we have to take the state exam?
We're getting there. Hold, and actually, George, I probably won't get to the state exam today, so we'll look forward to that first thing Thursday morning. So Thursday, we're going to talk about the specifics of your state exam, your application process, all that good stuff. Yeah.
I know that you said that we're given 4 hours.
Mhm.
Do we start our test as soon as we come in, or do you go over anything? Do we normally take the full 4 hours? How does that
So,
work?
and again, we'll talk about this on the 29th, but I do have to do a little check-in, a one-on-one check-in with you guys, because I need to see that stuff like your blank scratch paper is blank. I need to see that you don't have flashcards taped to the top of your desk, right? So I do need to do a little, I need to check your calculator and make sure the one you think you're going to use. So we will have to do, I'll log on early that morning, and I'll encourage you guys to come on early too. I try to get us started as close to 9 as I possibly can, but a lot of that depends on when I can get you guys checked in.
Okay.
This is a smaller class, so it won't take long. A couple classes ago, I had like 50 some of you. I didn't think I was ever going to get through check-in, but we did. So we will have to do that, Mary, at first. And
Okay.
again, we'll go over what I'm looking for. I will say this about our class exam. Let me go ahead and say this now. You must take our end of class exam in a distraction-free zone. If you are not currently in a distraction-free zone, you got 30 days to find one. Because if I see you or somebody else in the room with you, I can only assume you're cheating. And the Real Estate Commission says if I suspect you of cheating, I am to take your exam right then and there. So I think you guys, I actually applaud you guys as far as distractions. You guys as a class have done really good. And I thank you guys for committing and being in a distraction-free area. Continue to do so, and certainly secure that distraction-free zone for the exam on August 31st. Everybody good with that? Perfect. Thank you. Any other questions about our dates, upcoming dates? The other thing I want to go over with you guys today is your midterm. We finished unit 10. So now it's time to do a midterm. It's okay. Breathe. It's okay. Breathe, breathe, breathe. You may remember from the first day of class, you remember our welcome, our little introduction to the class? And we talked about the requirements that you have to get out of this class. To get out of this class and go on to take your state exam, you have to receive a certificate of completion from Lane. And there are certain things you have to do to have that certificate of completion. You have to meet the attendance requirements. How many hours are you allowed to miss? 15. That's the attendance requirements. If you have 14 hours and 59 minutes, you are eligible for this certificate of completion. Also, you have to pass the end of class exam. And then the third piece is you have to take the midterm exam. Attempting the midterm exam is mandatory. What does mandatory mean? Yeah, if I decide not to do it, I don't have to. Well, I mean, I can't make you do it, but here's the bottom line, guys. If you don't attempt it, you won't get your certificate of completion. So the midterm is mandatory. Please hear me. I'm not looking for pass or fail. I am looking that you attempted it. I am looking that you took it, that you tried. I suggest you guys treat the midterm as if it were a real test. I suggest you sit down, give yourself the allotted time, which we'll look at, give yourself the allotted time and pretend like you're sitting down on test day. Because if you take the midterm seriously, this should answer the question. If I were taking the end of class exam today, how would I do? So the way we're going to handle the midterm, if we look up here, still in the online learning system, under the 50% review and midterm exam section. So we're in this section, and we have a midterm exam just for us. So you want the 50% review and midterm exam. And the one you're looking for is the Julie only. This link is now live. And this link will stay live through Monday night. This link will no longer be live after 11:59 p.m. on Monday. So you guys have the better part of a week to take the midterm. Is that fair? I think it's either, I want to say it's 2 hours. It's either an hour and a half or 2 hours. Don't hold me. We'll have to click on it and see. There's 55 questions. There is no math on the midterm, but you guys have got to attempt it if you want to get credit to get that certificate of completion. Again, the link is live. Please don't start it now. Wait 25 minutes until class is over. Please don't try to take it next Thursday during class. So we're not going to use this as a distraction. Somebody says, does it begin today? Yes, it's live right now. And it will stay live until 11:59 on Monday. Units 2 through 10 and 20. Remember, 20 is our environmental unit, super scary unit. So 2 through 10 and 20. What do you think the big concentration of the midterm is? Units 7, 8, 9, and 10. Questions from other units as well. Again, I'm not looking for pass or fail. I'm looking that you try. Once you complete the midterm, treat it like a real test. Close the door, tell your family to leave you alone. Treat it like a real test. This does a couple things. First off, this gives you exposure to class marker. So help you be better prepared for your exam because you've now used it with the midterm. You guys, please understand, the midterm is not for me. The midterm is for you. It's a checkpoint. It allows you to see where you are right now. If you pass, keep up the good work. If you don't, what do you need to do to get ready for August 31st? Once you complete the midterm, I will get your results automatically, just me, so you don't have to worry about sending them to me. You will also get your results. And in addition to your results, it has like a breakdown of how many questions you got right from each unit. So it'll tell you not only your overall score, but your score for each unit. And you could use that report to help you identify which units you need to go back and review. So if you bomb unit 6, I would put unit 6 down to go back and review. Does this make sense? Use it as a checkpoint. Yes, units 2 through 10. Unit 1 is just our warm up. I'm not worried about that. So units 2 through 10 and 20 is what the midterm's on. No math. Questions on the midterm? We probably won't have time to go over this in class. However, as always, if you guys have questions on a particular test question or something, a midterm question, just reach out to me. Screenshots really help me. Allows me to see what you see. I need, let's see, there's, counting myself, there's 19 of us on the call. I need 19 thumbs ups about the midterm. What happens if you don't take the midterm? You're done. Thumbs went down. That's right. Not good. If you don't take the midterm, you're not eligible for your certificate of completion. If you don't take the midterm, you're done. Questions? Can you start and stop the exam? No. Great question. Thank you. Once you start it, you're in. So that's why I say, I can't remember. I think it's 2 hours. Why don't y'all just give yourselves 2 hours? Maybe you'll need that whole time. Maybe you won't. But a lot, 2 hours in your calendar. This is midterm time. And again, my suggestion, take it like a real test. Pretend that you're sitting down on test day. This is a one-time link too. So again, make sure you have that 2 hours devoted, distraction-free time. What else? If you don't finish it, does it still count as intent? Yep. You get one shot at it. Monday at 11:59 p.m. So this link is live until 11:59 p.m. Meaning if you started at 11:55 on Monday, you only got 4 minutes. So I recommend doing it before Monday night. You got to log on at least by 10. If you're a daredevil and like to wait till the last minute for things. And if you're up at 10 o'clock at night taking a test, good for you. Would the attempt count towards us taking the midterm? Yes. So failure to complete the midterm will result in you not being eligible to take the final exam. Your score does not matter, but you must take the exam. All you have to do is take it. I'm not looking for pass or fail. Yes, ma'am.
So you said that once we finish it, it'll provide us with a report of how many questions we got right and wrong for each unit.
Mhm.
It tells us, does it just tell us the amount or does it tell us the specific questions? Like, can we review the material of the exam or just the score and
Just the
accuracy?
score. And the reason for that, Joy, we don't, because the commission, and remember, we're treating this like a real test. So the real test, the commission does not allow you to review your answers or your questions, pass or fail. We can never let you see those questions again. So because we're treating it like a midterm, when you're done, all you're going to see is that report. You won't see specific questions.
Okay.
Specific questions for the midterm, that's where you come to me. So if there's something that's tripping you up, make a note of it and then reach out to me. And I want to work through it with you, but we got to treat this like a real test. And the real test says we can't go back and review questions.
Okay. Thank you.
What else? About anything. Let's just open it up. What the heck? Thoughts
Well,
on
so-
life? Yes, ma'am.
Since it's about anything now, and you said that
Uh-oh.
there's no math, which I expected to
You
be
were ready
math,
for that, okay?
is there a place or is it individual chapters that we can find that has all of our formulas?
Well, you have formulas on flashcards, or you have a piece of paper called formulas where you're keeping them together. No, I do not have a cumulative place for formulas.
Well, I've been writing them down, but it's like then I have to dig on throughout my entire thing. And so,
So I recommend going back through, because we're only a couple formulas in. So I recommend maybe this weekend going through and getting them on flashcards
to
or
get
getting
them
them
in
in
one
one place.
area.
I
Okay.
tell you guys right now, with financing, we start financing on Thursday, units 14 and 15. And with financing, it makes sense that it comes with math. So units 14 and 15 are heavy math. So we're probably picking our calculators again up on Thursday and all next week. So definitely want to get caught up on those formulas now, so you'll be ready for the heavy math units.
It's Julie.
Mhm.
In front of your book, the first page, which is it does have a couple of formulas written down. on the
Yeah, I think what
back
she
side.
said, LaDon, you're breaking up, so let me make sure I heard you correct. But the inside covers of your textbook does have some formulas. I think there's the inside of the front cover and the inside of the back cover. LaDon, is that what you were saying?
Yes.
Yeah, okay. Yeah, thank you. You were breaking up on us. So your inside covers, there's more formulas on the inside covers than what you need though. But thank you, LaDon. That could be a great place to start. So your inside front cover of your book and your inside back cover of your book. How often do we look at the inside covers of the book, right? Right. So yeah, hey, look, we got formulas there. Again, there's more there than what you need. So I do think in addition, using that as a reference, but going back and just picking up what we covered. If we cover it, it's a good candidate. Question comes in, how much of the final exam is math? My exam has 8 or 10 questions. I never remember. It's either 8 or 10 questions, and I think it's about that many on your state exam as well. So what we've been saying about the math all along, the math alone can't fail you. So you can miss all the math and still pass these exams, but you will have some math. And if you want an attempt to get the math right, you got to know the formulas. 80% of the math is knowing the formula. So thank you, Mary, for that. Thank you, guys. This might be a good opportunity. We did math in units 3, 4, and 8 so far. 3, 4, and 8 so far. Math coming, 14, 15, and 21. Lots of math in our future.
So are we gonna get through 14 and 15 on Thursday, or do you
No.
think it might spill? No?
No.
Okay.
We'll get there. Like I said, what I provide you guys is a tentative schedule. That means subject to change. The other thing I say, you guys, please don't worry about time. Worrying about time is my job. This may or may not be your first time through pre-licensing, but I guarantee you it's not mine. So y'all let me worry about time. And right now I'm not worried about a thing. So we're good. What else? This is fun. I always get nervous when I open it up for who knows what's getting ready to fall out somebody's mouth. What else? This is kind of our good checkpoint. This is why I like the midterm. I mean, we're about halfway through. So the good news is we're halfway through. Guess what, though? We still have half of the material to cover. Pass or fail, our scores, we're sitting at about 70, 75%. If you aren't worried, we aren't worried, good. I'm not worried. I got plenty of other things to worry about. Like, what am I going to do for lunch today? I need to figure that out pretty soon, though. Did you say you were going to tell us about signing up to take the state exam? Yes, I don't have time to do that today, so we'll start with that on Thursday. So that's a great segue. Thank you. On Thursday, we're going to go through our real estate licensing in North Carolina booklet. You guys got this from Lane when you registered, and she sent you the email. She asked you guys to look at it. I don't know what version you guys have. They just updated this in March. So make sure you're always looking at the current version. And this is the booklet that we're going to go through first thing on Thursday. And this is the booklet that says, okay, I passed Julie's class. I passed pre-licensing. Now what do I do? And that's where this booklet picks up, is where you guys leave off with me. So we'll go through and talk about this on Thursday, this process. We will do that first, and then we'll jump into unit 14. Financing. What else? I kept you guys a few minutes last time, and I promise I let you go a little early today to make up for it. And I had a note to let you go at 12:55, but honestly, at 12:49, I'm not starting something new just for 5 minutes. So you guys are going to get 10 minutes for me keeping you over 2 minutes last week. Is that fair? I just gave you 8 minutes. Okay. Can you order it free from the website? This booklet from the website? I don't know about that, but you can download it. So you can download it and save it. Have I been selling homes since I've been teaching this class? I was in sales before I started teaching. I don't do much sales
Question,
anymore.
Julie.
Yeah.
On the midterm and like even on the state exams, do they allow you to like go back and double check your answers? So can you go back and like change your answers or yeah.
Yep, you can do all that. So watch that tutorial because it walks you through that. You may want to do that before you take the midterm, right? But either way, the midterm will expose you. That's another thing I like about the midterm, is so you guys can have experience with class marker before your exam. Kind of take that question out of test day. Yeah, I don't do much in sales anymore. It's going to be really honest with you guys. It's hard to do this and do sales because Murphy Law says as soon as I log on to do a 9 to 5 post licensing class, I'm going to get an offer on one of my listings. And so it's just really, really hard to be at 2 places at once. So I made the decision a couple of years ago and I picked you guys. So I'm not directly involved in sales anymore. I am still with my real estate firm. I'm more of an admin role. So I do like a lot of behind the scenes stuff that you would never know existed. Yep, class marker, you can click on, there's a link on every page that says see all questions. It'll tell you if it's answered, unanswered, bookmark. So again, watch the tutorial before you take the midterm and that'll prepare you for that. Good enough? All right, I'll talk 2 more minutes. So now you only get 9 minutes out of me. Still pretty fair though, right? All right. You guys have a great afternoon. I will see you Tuesday morning. We will do our relink book. Damon, I'll answer that on Thursday. Did I just say Tuesday? Whenever we're supposed to meet next, I don't know. Y'all know better than me. When I look at my calendar and it tells me I'm supposed to be here, I log on. So whenever we're scheduled to meet next, we'll start with our relink book and then we jump into unit 14. So that's where we are. Y'all have a good afternoon.
Have a good day.
Thank you. You too.
Are we able to connect?